Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good evening. Good evening, my friends, and thank you so much for coming to hang out with me today on this Tuesday, November 12th of 2024. I feel like I haven't done an evening show in so long. It feels like the evenings have been taken up with other things. But now that the Delphi verdict is in, the evenings have freed up a little bit. How is everyone today? Today, I found myself in Manhattan criminal court. I went to the Daniel Penny trial today. And who did I bump into in the hallway of the 13th floor of the Manhattan criminal court at 100 Center Street? But our mutual friend, Mark Bederow. How about that? He's like the mayor there. He knows everybody. Everybody knows him. I saw some people I knew too. But I also saw Jeanine Pirro. So that was kind of cool. I don't know if you guys know who Sanford Rubenstein is, but he was there as well. And my favorite sketch artist, Jane Rosenfeld, that was pretty cool. And it took me a little while to get into the courtroom, actually. I had to wait. And then I went in, and then Mark and I had a very lovely lunch in Little Italy together. And we got to catch up, and it was really, really fun and really cool. And it was funny because he texted me this morning and said, hey, I'm going to be in 100 Center Street all day today. I don't know what you're doing. And I said, well, that's really funny because I'm getting ready to get on the train because I want to go see the Daniel Penny trial. So that was pretty cool. I'll report on that tomorrow for you guys with all of my thoughts about that trial, which is, for those of you who don't know about it, you should know about it because it's another trial that's being shadow banned. There are no cameras in the courtroom. And it's about a young Marine who, in my opinion, is a hero and restrained a crazy passenger who came on an F train in the subway, if you know, you know, screaming and threatening to kill people. And he was on synthetic marijuana and he demanded money and he said he didn't care if he went to jail and he wasn't afraid to kill people. People were terrorized. This young Marine subdued him. When the first responders got there, they found a pulse. He was breathing, but he tragically died later at the hospital. And Daniel Penny is being prosecuted for manslaughter, facing up to 15 years in prison. So there's that. And there's no cameras in the courtrooms, and there's not a lot of press on this. Nobody's covering it. So although I've done 2 shows to catch you guys up on days 1 through 4 of this trial that I find to be a travesty, I had to go there for myself today and see it for myself. And there's some press outside, not a lot. Some press inside, not a lot. The protesters that were outside were inside watching the trial when I was there. It's a large courtroom, at least double the size of the courtroom that Karen Reed's trial was in. And it's crazy. It's It's crazy, but I'll report on that to you guys tomorrow. Tomorrow we're going to cover the Karen Reed hearing in the morning at 10 a.m. I've set up the stream for 9:30. After this hearing, after this show is over tonight, it's going to teleport you over to the morning stream, so you can just hit the reminder bell or button or whatever, and then come back and watch that with me tomorrow. But what I thought we'd do tonight is go over the papers that came in today in the defense opposition to the motion for Bill Reed's cell phone records. And I also have another letter from our friend Mark Bederow that he wrote in the Aiden Carney case, demanding some more stuff from the alleged victim in the Aiden Carney wiretapping and witness intimidation case, because apparently she just can't keep her mouth shut, and she goes all over the internet bragging about things that she says that she has, which of course causes more discovery. It's like, why don't you just stop with the internet? Just stay off the internet. You don't need to post all your most private thoughts and concerns. And, it's not a flex. It's not a flex when you're throwing your friend under the bus, saying that your friend, the queen of the massholes, has the evidence to prove that, Aiden did something else, and also implicating Mike from Young Jerks in their ridiculousness. But, it's another day in Canton, just another day, some more BS. But the more BS they spew and the more flexes they try and put out there, the more discovery is going to come of that. So it's not so smart. Not really being wicked smart over there. Just not. But I mean, is what it is, I guess. What I do not have in my possession, and I cannot access yet, is there's another Commonwealth discovery exchange. It's document number 415. It is not available yet online, although it's been filed with the court. If anybody has it, feel free to email it to me. I also do not yet see a response logged in from the defense with regard to the motion for the Boston 25 Ted Daniel outtakes. So if they come in the morning, we will see them. We will go over them in the morning before the hearing. If not, then we're just going to fly with the arguments together. That's what we're going to do. That's what we do here. Tom CPU got assaulted at the Jill Daniels hearing this morning outside of Stoughton. Somebody saying, can't keep up with it. It's just absolutely, it's so wacky. Yeah, well, I'm going to catch you up, Lee. Don't worry, no spoilers. I'm going to catch you up. Hello, everyone. Hello, Animal Lover 555. We're so happy you found this channel too. Everyone say hi to Animal Lover 555. Welcome. I think you're going to like it here. Okay, so as you may recall, the Commonwealth is all of a sudden saying that it wants to call Bill Reed as a witness, Karen Reed's dad. Well, they didn't call him during the first trial, but now what they want to get from him is all of his cell phone records from the 24-hour period before Officer John O'Keefe's body was found, and for actually 1 month prior to that, because they claim that there's going to be something in those records that is going to somehow impeach somebody at trial and going to show a pattern of how often she called her father in the month leading up to the tragic death of Officer John O'Keefe. But they're saying it's not a fishing expedition. And we talked about this. And I said, why would they need this? They already have Karen's records. Why do they need to know when she talked to her father? But here we go. Let's see what the defense is arguing in response to that. There's some interesting stuff attached to it as well. So we're going to get to see all of it. All of it. Bring it. This is filed today. I can't even read the time. It's so faint on there, but it was at some point today. It was filed by the defense, and this is only in opposition to the request for Rule 17 Verizon records of Bill Reed, who is, as you know, or may not know, the father of Karen Reed. So please hold your questions. I will not be able to read the chat while I'm reading to you. I can't be your pen pal. Can't babysit your kids. And I can't respond to you. And you spam me 5 messages a day and ask me to forward them to other people like Andrea Burkhart and or Mark Bederow and or I will not forward your emails to anyone. I will not. I will not click on links. I cannot pick up your child in California and buy him a plane ticket to Brazil and fly him to Brazil to meet you, even if you promise to give me 10 acres of land. I just can't do that. It's crazy. My only pen pal is Team Brittany. Thank you. Thank you, Scott. And here we go. This is defendant's memorandum in opposition to Commonwealth's motion pursuant to Rule 17 of Criminal Procedure directed to William Reed and Verizon. For those of you who are not familiar, Rule 17 is the rule in Massachusetts under which all third-party records must be requested. So it's not defendant's records, it's records of any third party. For example, when Karen Reed's team made motions to try and get Jen McCabe's cell phone records, Jen McCabe's Google searches, Brian Albert's cell phone records. Those are all Rule 17 motions because they have to do with third parties. Mr. Reed, her father, is a third party in this case. And here we go. Now comes the defendant, Karen Reed, Ms. Reed, and respectfully requests that this honorable court deny the Commonwealth's Rule 17 motion for an order directed to William Reed and Verizon Wireless. The Commonwealth's motion is a fishing expedition and an inappropriate attempt to invade Mr. Reed's privacy. All plausibly relevant information that the Commonwealth could glean from the requested cellular records is redundant and duplicative of the information already contained in Ms. Reed's cellular, telephone, and Verizon records, which have been in the Commonwealth's possession since the start of this case. They have. The Commonwealth has utterly failed to demonstrate that any information contained in Mr. Reed's cellular records, beyond information that is already in the Commonwealth's possession, is relevant to the instant proceeding. The incident request constitutes a thinly veiled attempt to embark on a blind inquiry into Mr. Reed's personal information and cellular data. Indeed, to the extent that the Commonwealth seeks records unrelated to Ms. Reed, the request is overbroad and an impermissible and invasive violation of Mr. Reed's privacy. For these reasons, the Commonwealth's motion should be denied. Factual background. On October 18th of 2024, the Commonwealth filed a motion pursuant to Rule 17 requesting records from Verizon for inter alia, Latin lesson of the day. Inter alia means among other things. If you know, you know. So you don't just learn about the law here. Sometimes we have a little Latin lesson. Customer data and personal information associated with Mr. Reed's cell phone. Mr. Reed is Ms. Reed's father. Mr. Reed was not present at CF McCarthy's, the Waterfall Bar and Grill, or 34 Fairview Road in Canton, Mass. on the days of January 28th or 29th of 2022. Mr. Reed is not a witness to any of the relevant issues involved in this case and was not called by the Commonwealth to testify in the initial trial of this matter. Based on the showing set forth in the Commonwealth's papers, it appears that they are seeking communications between Mr. Reed and his daughter between December 30th of 2021 and January 30th of 2022. However, all of the communications at issue are already in possession of the Commonwealth. Actually, whoever drafted this, I think it was Misty and Eddie, was kind enough not to point out the typo. Maybe he will later. I think the motion papers say 2002, not 2022. However, all the communications at issue are already in the possession of the Commonwealth. Indeed, Troopa Procta seized Ms. Reed's cell phone on the afternoon of January 29th of 2022. Ms. Reed's phone was subsequently searched by the Massachusetts State Police pursuant to a search warrant issued on February 2nd of 2022. That was the same day as her arraignment. Thus, the Commonwealth has in its possession, was it her arraignment or her arrest? I can't recall right now, and I don't want to misspeak. It was one or the other. Thus, the Commonwealth has in its possession a full extraction of Ms. Reed's cell phone. The extraction, the footnote 1 is that the search warrant is attached as Exhibit 1, and that's dated February 2nd of 2022, 2/2/22. For you numerology experts out there, The extraction obtained from Ms. Reed's cell phone includes all calls between Ms. Reed and her father on January 29th of 2022 and all calls exchanged between Ms. Reed and her father in the month preceding that date. Moreover, on December 7th of 2022, the Massachusetts State Police obtained Ms. Reed's personal cell records from Verizon pursuant to a search warrant for the period of 12 a.m. Eastern Time on January 29th of 2022, so it would be midnight, to approximately 7 a.m. on January 29th of 2022, including the following information: subscriber records, specialized location records, call text data detail records, time on tower and or sector, electronically stored records, and carrier key. Footnote 2, which says the search warrant for Karen Reed's Verizon data attached here too as Exhibit 2. It's interesting to me that they didn't even request that until nearly a year later, December of 2022. There are no inconsistencies between the data extracted from Ms. Reed's cell phone and the data from Verizon's carrier side call and text records. In other words, nothing from Ms. Reed's phone was deleted or altered in any way from the time electronic communications were made to the time the state police collected the records. Footnote 3. This is particularly noteworthy in this instance, given the same cannot be said of other parties present at 34 Fairview on the days of January 28th and 29th. Give me some shovels in the chat. It's a little dig. It's a little dig. Little dig at somebody. More than one person. Ms. Reed's father, William Reed, has never been called by the Commonwealth to testify as a witness in this case. Now, 3 years later, the Commonwealth seeks to invade Mr. Reed's privacy by obtaining all of his call and text records for an entire month prior to January 29th of 2022. The Commonwealth seeks the following records from Mr. Reed and his cell phone provider. 1, subscriber information associated with Mr. Reed's phone number. 2, records for all Verizon transactions, including all call records, call detail records, SMS and MMS text records, and all data use records associated with Mr. Reed's phone number for the period of January 29th of 2022 until January 30th of 2022, and records for all call records and call detail records for the period of December 30th, 2021 to January 30th of 2022. In support of this overbroad request, the Commonwealth makes several references to Ms. Reed's cell phone data, which it obtained via the aforementioned search warrants. The Commonwealth states that in the aftermath of Ms. Reed being unable to get in touch with Mr. O'Keefe in the early hours of January 29th of 2022, Ms. Reed made several phone calls, including to William and Janet Reed, her parents. The Commonwealth goes on to explain how they plan to call Mr. Reed as a witness in the upcoming trial to question him about, quote, conflicting statements made by Ms. Reed on January 29th of 2022. At best, the Commonwealth's request is an overbroad fishing expedition. At worst, it is an attempt to harass Ms. Reed's family. In its Rule 17 motion, the Commonwealth states that Ms. Reed made 3 phone calls to her mother at 1:14 a.m., 4:38 a.m., and 4:42 a.m. on January 29th of 2022. Notably, none of these calls were answered. Ms. Reed did not make any calls to her father, Mr. Reed, on January 29th, 2022, until after she discovered Mr. O'Keefe lying incapacitated on Brian Albert's front lawn at 34 Fairview Road at 6:30 a.m. Exhibit 3. The Commonwealth is able to reference all of this information because they are already in receipt of Ms. Reed's phone records, confirming the same. As set forth herein, the Commonwealth has failed to establish good cause for its request to invade Mr. Reed's privacy interests and search his phone for irrelevant information under Lampron. This is exactly what I was saying when we went over these initial motion papers. I said they already have her records. Any calls between her and her father, any texts between her and her father are going to be in her records. And here's the argument. Here's the argument. 1, legal landscape and evidentiary standard. When a party moves the court to subpoena documents in advance of trial, the burden is on the moving party to establish good cause for the court to grant the motion. Commonwealth v. Lampron. We hear Judge Kearney talk about Lampron a lot. She'll question the non-Massachusetts attorneys. And how does that comply with Lampron? And the test under Lampron, Ms. Little, not me, Ms. Little, the other Ms. Little, who's on the defense team, who is no relation. How does that comply with Lampron? Under Lampron, it's like she's testing her like she's a law student. Quoting U.S. v. Nixon, 1974. Good old Tricky Dick. Good cause is established by satisfying 4 criteria. 1, that the documents are evidentiary and relevant. 2, that the documents are not otherwise procurable reasonably in advance of trial by exercise of due diligence. 3, that the party cannot properly prepare for trial without such production and inspection in advance of trial, and that the failure to obtain such inspection may tend to unreasonably delay the trial. And 4, that the application is made in good faith and is not intended as a general fishing expedition. The moving party bears the burden to set forth with particularity some factual basis indicating how the privileged records were likely to be relevant and material to an issue in the case. The records sought by the moving party must have a rational tendency to prove or disprove an issue in the case. The evidentiary standard of relevance applies. The moving party is required to make a factual showing that the documents sought are relevant and have evidentiary value. Rule 17 of the Massachusetts Rule of Criminal Procedure is not a discovery tool. Rule 17 is reserved for evidentiary materials that are likely to be admissible at hearing or at trial and not invoked merely for the exploration of potential evidence. Potential relevance and conclusory statements regarding the relevance are insufficient. The movement's request must be accompanied by a supporting affidavit containing a factual showing that the above requirements are met. The facts in the affidavit must be specific and in the personal knowledge of counsel's sources. Mere speculation is insufficient to support this burden. The Commonwealth's request for unfettered access to the personal information of a party so peripherally related to the matter, especially in light of the comprehensive lack of evidence of materiality demonstrated by the Commonwealth, cannot be allowed. The court must uphold the interests of fairness and justice by preventing unnecessary harassment of witnesses caused by burdensome, frivolous, or otherwise improper discovery requests. A witness should be forced neither to retain counsel nor to appear before a court in order to challenge, on the basis of a partial view of the case, potentially impermissible examination of her personal effects and the records of her personal interactions. 2. The Commonwealth has failed to meet the requirements necessary to satisfy the Lampron standard to compel production of the requested documents. The Commonwealth's request for Mr. Reed's cell records fails to satisfy all 4 of the necessary elements required under Commonwealth v. Lampron. The Lampron requirements are conjunctive. If the movement fails to satisfy any one of the 4 requirements, the court must deny the motion. So it's not either or, it's all of them. The requested records are not evidentiary and relevant. That's point A. The Commonwealth must show that the requested documents are evidentiary and relevant. They have failed to do that here. The Commonwealth requests all call and text data from Mr. Reed's cell phone on January 29th and January 30th of 2022. The Commonwealth claims to be requesting this information in order to expose conflicting statements made by Ms. Reed to her father, Mr. Reed, in the early hours of January 29th of 2022. However, the Commonwealth is already in possession of all of the texts and calls between Ms. Reed and her father on January 29th of 2022. No such evidence exists. It doesn't exist. They're saying you already have all of her texts with her dad. If there was a conflicting statement in those text messages, you would already have it. You took her phone the same day, January 29th of 2022. Proctor just took it. He just did. He didn't have a warrant. He just took it. He didn't get the warrant until 4 days later. He just took it. They did a complete and total extraction, and there was nothing deleted from that phone. It doesn't exist. In support of its request, the Commonwealth references a television interview where Mr. Reed was specifically asked whether Ms. Reed believed she may have hit John, to which Mr. Reed replied, no, 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 she felt she struck something. The Commonwealth has misconstrued, intentionally or otherwise, Mr. Reed's statement in that interview in an attempt to insinuate that this was some sort of admission by Ms. Reed to her father. Significantly, in recent coverage of the case by Boston 25 News, reporter Ted Daniels clarified, isn't it Daniel? Clarified that Ms. Reed went on to state during that same interview that his daughter remembered backing up and hitting something when she went out to look for Mr. O'Keefe that morning, i.e., Mr. O'Keefe's Chevy Traverse. Footnote 4, which reads, Boston 25 News, prosecutor in Karen Reed case seeks records from Boston 25 News, and then they give a link to that piece, or I'm not sure if it's a video or an article. It is difficult to understand how information contained in Verizon's call data for Mr. Reed's cell phone, which includes call direction, incoming or outgoing, recipient phone number, and call duration, but most notably not call content, is useful to this theory of the Commonwealth or serves any relevant purpose in this case. The Commonwealth claims that Ms. Reed made this statement to her father at the hospital at approximately 7:30 a.m. on January 29th of 2022. The Commonwealth then claims that they require Mr. Reed's cellular data to impeach this statement because they believe such a conversation could not have taken place at the hospital and must have taken place earlier that morning before they arrived at the hospital. This reasoning does not align with the time period for the records the Commonwealth has requested. The Commonwealth is already in possession of Ms. Reed's cell phone from the time she acquired the device to the date it was seized on January 29th of 2022. Even though Ms. Reed's phone contains sufficient information for the Commonwealth to discern if and when a call between Ms. Reed and her father took place, the Commonwealth also has access to Verizon carrier call data from Ms. Reed's phone for all activities from 12 a.m. to 7 a.m. on January 29th of 2022. As is common knowledge, calls take place between two parties from one phone to another, unless it's from one butt to another during sexy time. I mean, not here, but with regard to some other parties, maybe. For a given call, the exact same information is recorded by the carriers of each participant, with the only difference being the direction of the call. Because the Commonwealth already has access to information related to any calls between Mr. Reed and his daughter from Ms. Reed's cell phone and carrier, any other information contained in Mr. Reed's Verizon cell records is not relevant. Notably, and they have emphasized this for us in bold and underline and italics. Notably, Ms. Reed did not make any calls to her father on January 29th, 2022, until after she discovered Mr. O'Keefe lying incapacitated on Brian Albert's front lawn at 34 Fairview Road at 6:30 a.m. We're going to look at those records because they're attached as Exhibit 3. Thus, Mr. Reed's cell records from January 29th, 2022 do not have a rational tendency to prove or disprove an issue in the case under Lampron. The Commonwealth also requests all call data from Mr. Reed's phone for the entire month preceding January 29th, 2022. The Commonwealth claims this information is relevant to show a lack of pattern of Ms. Reed calling her father in, quote, the middle of the night. However, as explained above, Ms. Reed did not call her father on January 29th of 2022 until 6:30 a.m., moments after Ms. Reed discovered her boyfriend of 2 years incapacitated on Brian Albert's front lawn. Thus, even setting aside Mr. Reed's privacy interest in a month's worth of call history, this request is facially irrelevant. Whether Ms. Reed typically calls her father in the, quote, middle of the night has no bearing in this case because Ms. Reed did not call her father in the middle of the night on January 29th of 2022. Thus, this factor has no rational tendency to prove or disprove an issue in the case under Lampron. Moreover, the Commonwealth makes no showing whatsoever as to the relevance of Mr. Reed's calls with other individuals, not Ms. Reed, for a month between December 30th, 2021 and January 29th of 2022. Thus, the Commonwealth has failed to show that this incredibly broad request is evidentiary or relevant. B. The requested records are otherwise procurable in advance of trial with reasonable due diligence. Lampron also requires that the Commonwealth show that the requested documents are not otherwise procurable reasonably in advance of trial by exercise of due diligence. The Commonwealth has failed to make that showing here. All of the information requested by the Commonwealth is already in its possession. In fact, the Commonwealth has been in possession of Ms. Reed's entire call history predating December 30th of 2021 for more than 2 years. They have her entire call history from the time she obtained that particular phone up until the time that they seized it. The Commonwealth has access to all information contained within Ms. Reed's phone from the time it was activated through the date it was seized on January 29th of 2022. The Commonwealth has never raised concerns about the authenticity of the information contained in Ms. Reed's cell records. In fact, they relied on those records repeatedly throughout the initial trial in this matter. By whom? Who was the witness who extracted and analyzed the phone data? You know who it was. Our friend, Trooperino, Trooper Nick Garino. Same Trooperino who did not find 34,000 text messages between Sandra Birchmore and Matthew Farwell in Matthew Farwell's phone, despite the fact that the MSP and the Canton PD had possession of Sandra Birchmore's laptop that had all of those messages contained therein, and still declined to rule her death anything other than a suicide until the feds jumped in. Now Matthew Farwell is sitting in federal jail waiting his criminal trial on the murder of Sandra Birchmore. Had the Commonwealth exercised reasonable due diligence in advance of filing its Rule 17 motion, it would be apparent that the Commonwealth is already in possession of the requested information. Therefore, because the Commonwealth has already procured the requested information, its motion must be denied. C. The Commonwealth's failure, the Commonwealth can effectively prepare for trial without the requested records, and the failure to obtain this information will not unreasonably delay trial. The Commonwealth's failure to obtain the requested records will not unreasonably delay the trial because the Commonwealth is already in possession of the information it seeks from 2 different sources, i.e. the Celebrite analysis conducted by the Office of the Attorney General of Ms. Reed's personal cell phone, which is, the FBI, Josh Levy's office, and Ms. Reed's cell phone records and Ms. Reed's Verizon records from January 29th of 2022. Any records of calls from Mr. Reed and or his cell phone carrier will merely constitute a third copy of these communications between Mr. Reed and his daughter on January 29th of 2022. The Commonwealth does not need to invade Mr. Reed's privacy in order to prepare for trial. As such, its request must be denied. I haven't read the rest of this yet, but I'd ask for costs on this motion too, because it's not really made in good faith. Oh, look. Look, this is a cold read. The incident request is not made in good faith and is an inappropriate fishing expedition. The Commonwealth's request is not made in good faith and is not narrowly construed and appears to be a fishing expedition to sift through Mr. Reed's cell phone records for potential evidence unrelated to his communications with Ms. Reed. This court has repeatedly emphasized over the course of these proceedings that Rule 17 is not a discovery tool, Mr. Jackson. It is not a discovery tool, Mr. Yannetti. You know that, Mr. Yannetti. You practice law in the state of Massachusetts. It's the way we do things here. It's not a discovery tool under Lampron. Rule 17 is not invoked merely for the exploration of potential evidence. And that is the same reason that she denied most of the defense's Rule 17 motions during the pretrial of the first trial. And that is why Karen Reed's team had to go up to the appellate court or the SJC. I'm not sure which court they went up to. They had to go up on appeal with regard to Brian Albert's records and Jen McCabe's records, and it was reversed in part. And they were able to get some of them, not all of them. The duplicative nature of the records sought exposes the Commonwealth's true intentions. If the Commonwealth had alternative reasons for seeking Mr. Reed's cell records above and beyond any calls or text messages with his daughter, those reasons were not set forth in the motion supporting affidavit. There is simply no reasonable justification for the Commonwealth seeking all of Mr. Reed's call records for a month without any limitation whatsoever as to the recipient of those calls. The court must balance the Commonwealth's right to receive relevant information with unwarranted harassment of witnesses and third parties. As this court has acknowledged, electronic devices are repositories of a vast store of sensitive information that can provide an intimate window into a person's life. Citing some cases. An individual, therefore, has a compelling privacy interest in the contents of his or her electronic devices. Given that the Commonwealth has not shown that the information contained within Mr. Reed's cell records is relevant in any way outside of the information that's already in the Commonwealth's possession, the scale tips heavily in favor of Mr. Reed's privacy interest. Finally, with respect to the requested time period, the Commonwealth's request is overbroad. In its request for all call and text records from January 29th and 30th, 2022, the Commonwealth claims that these records are limited to the immediate time and aftermath of the alleged crime and document the relevant interactions between the parties. The Commonwealth's request for Mr. Reed's records from January 30th, 2022 is arbitrary. The Commonwealth has failed to allege any particularized facts in its affidavit suggesting why it believes relevant information will be obtained from Mr. Reed's cell phone on January 30th of 2022. The Commonwealth has not listed with particularity any facts of import that took place on January 30th. In fact, the basis for the instant request is that the Commonwealth believes Ms. Reed and her father were communicating before Ms. Reed was in the hospital at approximately 7:30 a.m. The Commonwealth has presented no basis whatsoever demonstrating the necessity of obtaining Mr. Reed's cell records from January 30th. Thus, this request must similarly be denied. Finally, the Commonwealth claims to have made an effort to best protect William Reed's privacy rights by limiting its request to all of Mr. Reed's call data from December 30th, 2021 through January 30th of 2022, the entire month before. However, the Commonwealth's request is not narrowly tailored at all. The incident request appears to be a blatant attempt to fish for salacious information unknown to the Commonwealth, impermissibly seek discovery, violate Mr. Reed's privacy, and intimidate the Reed family by sending the message that their lives are subject to inspection by the Commonwealth. See Lampron. It's a great argument. Conclusion. For the reasons, the above reasons, and for those argued by defense counsel at the hearing of this motion, which will be tomorrow, Ms. Reed respectfully requests that this honorable court deny the Commonwealth's motion. Respectfully submitted for the defendant Karen Reed, XOXO, smooth as butter, Alan Jackson, pro hoc vice, and Elizabeth Little, pro hoc vice, Worksman Jackson and Quinn, and our friend David Giannetti and Ian Henchy, both of Boston, Mass. Dated today, which is November 12th, 2024. And we move on to Exhibit 1. Let's go to the chat for a moment and look to some of your questions before we move on to the exhibits. Deborah, Claire, thanks for becoming a new member. Welcome, Deborah. Mostly Harmless Fuzzball, thanks for the 5, says, it's not a fishing expedition, it's witness intimidation of Karen. Or if they want to call Mr. Reed a witness now, because they didn't call him during the first trial. And you know what? Bring it on. Bring it on. Really? Do you think that Bill Reed is not going to be the most sympathetic, genuine witness that would ever testify in this trial aside from Lucky Loughran? Bring it on. They're never in a million years going to call him. Are you kidding me? That's just ridiculous. It's a ridiculous even assertion that they would even want to call him. But okay, I dare ya. Loud Mouse, thanks for the 10. I just need people to know that my truck battery died today. And after I spent $200 on a new battery, my transmission bit the dust 30 minutes later. Laugh or cry kind of day. It's only 5 years old. I'm so sorry. That's terrible. I'm really sorry, Loud Mouse. I'm sorry that you that happened to you today. You should not be spending your $10 to tell me that, but we all sympathize with you because we've all been there. That's terrible. Does that include voicemail? No, it does not. I don't believe that it does. It includes, the call data is who called who, how long was the call, what time was it made. But they have all of that on Karen's phone. They have all her voicemails. They didn't ask for voicemails too. That's interesting. Sebastian, thanks for the 20. Out of curiosity, can the defense bring up the facts from other cases, i.e. Birchmore case, to show a pattern of behavior of the Norfolk DA and Canton PD to cover up crimes? What ways can they do that? Thanks. Well, I don't think that they can do that at trial for sure because she's never going to allow it. And I don't even know if that would be proper argument for some of these motions. It's an interesting thought, but I am not familiar enough with the Massachusetts Rules of Criminal Procedure to even give you an answer on that. But it is a great argument. And, maybe to impeach a witness, like, for example, Trooper Garino, could be brought up that he did not find 34,000 messages during the Sandra Birchmore investigation. That perhaps could be used for impeachment. Could be used at trial in certain ways. Michael Proctor, although I don't think that the Commonwealth is going to call him, but the defense certainly could. Who knows what else they have? Who knows what else they have? Michael Proctor was the lead investigator on the Brian Walsh case. Anna Walsh, Brian Walsh's wife, whom he's accused of chopping up and disposing all over town in dumpsters, was a very beautiful woman. Did he look for nudes in her phone too? Does it show a pattern of egregious behavior? Maybe it could go to pattern. Something else I found very interesting that I went over with you when we talked about the Walsh case is that I think it was Garino or Proctor, one of them in the affidavit, one of the Brian Walsh affidavits said that based on Brian Walsh's cell phone data, they could tell that one day Brian's cell phone location data was outside his mother's apartment building and another near the dumpster, and another day it was inside the apartment building. So apparently in the Brian Walsh case, they could figure that out, but they couldn't say whether or not John O'Keefe's phone was outside the house or inside the house because of the margin of error and all that other stuff. Remember that testimony? So yeah, it's a great point. Hopefully, if they can get it in, they will. And that's why they're looking to unseal all the sidebars that we looked at the other day. Because everything was argued at sidebar. We don't know what the evidentiary arguments were. And they need to be unsealed so that those arguments and those rulings can be used for the new motions in lemonade that we're going to see prior to this retrial. You know? So same players. I don't think that you could use it for the department, but I think that if it involves the same players and the actual witness itself, could be used for impeachment purposes. Camille, red herring, distract, keep focus off of facts. You think that's what they're doing here? Thank you, Sebastian, for your 20. Kevin the Sallyport camera became a YouTube member. Welcome, welcome. Misty and Eddie. Oh, I love it. I love it. Thanks to the 5. Love my show. Change my handle just for you. Thank you. I love it. I do love it. Thanks, Misty and Eddie. Elf gifted a membership. Thank you, Elf. You're so very kind and generous always to this channel. Knowing your bits from your bites. Another amazing screen name. You guys are killing it tonight. We do have the funniest chat on YouTube. You're the snark tank and you guys are hilarious. It is a very, very competitively funny crowd here because we have to laugh sometimes. Otherwise, we're just going to cry all the time. And what fun is that? None. Knowing your bits from your bites. Thank you for the $25 super chat. This farce should be dismissed with prejudice as the DA's office is totally incompetent. And if that were grounds, by golly, I think you've got it. They did make the motion. They did make the motion to disqualify Michael Morrissey from this case. It was denied. They did make a motion for Judge Kearney to recuse herself. Denied. Yes, that is true. Mark is on News Nation tonight discussing what's next and discussing, the DJT things. Yep. He was telling me about that. He's going to be out with Dan Abrams. I don't know what time Dan Abrams goes on. I think 9 o'clock. So take a look for him there. Thanks, Suze, for reminding me to promote that and plug it. Thank you. He was running off as he had to get on the train to go home to prep for his interview with Dan Abrams. Robin G, thanks for the 5 prayers for Karen and her family tomorrow. You got this, Team Reed. You got this. Yeah, it's Kelly. I think I saw Kelly Reed in the chat. Hi, Kelly Reed. Hello. Sending you prayers and strength as always. And we're here. We're here for you guys. Tracy says because they were too busy focusing on the Hill. Right. Right. Saying that, the up and down stairs thing wasn't really accurate on the Apple Health data for John O'Keefe. It could be he was just either waving his phone around in the car or going over a hill in the car. Then it would, it would register as steps under Apple Health data. It's embarrassing. BLT. Hi, BLT. Always appreciating my take. I mean, who doesn't love a good BLT? Thank you so much for the deuce. Appreciate you as well. You guys are funny. All right, back to the hi, Kelly. Hi, Kelly. Kelly's here. And look, Iceman is here. Iceman is with me through a lot of trials, a lot of stuff. He's here for lots of things and stuff. And we talked about something yesterday about how Richard Allen was not only allowed to see his wife twice in 13 months during the time that he was in the hole in solitary confinement. And Iceman, I went back and I looked at the chat, and Iceman said, if I could only see Melanie Little twice in 13 months, I would be devastated. That was awesome. So thank you. That was a very nice compliment. And he says, OMG, Melanie, you have the best chat with these creative screen name handles. I love it. Shout out to @knowing your bits from your bites. That's right. Yeah, Bob. He was doing the wave. Yep. Look, Jess even tried it out. Jess tried shaking his or her phone in all different ways, and it didn't say I walked up any stairs. Nope. Melissa says, Kelly, we're praying for all of you and sending big hugs. But this is just another example of more money that Karen Reed has to spend to oppose these ridiculous motions where, hey, Mr. Brennan, not for nothing, but if you did actually review the file, you would find out that you already have everything that you're now asking for. You've already got it. Because your illustrious investigator seized the phone the same day Your Celebrite extraction showed that nothing was deleted. And I mean, maybe you waited until a year later, but you also got all her location data and everything else. So you've got everything you need. Peace out. But now she's got to pay her attorneys to oppose this motion. And it's frivolous, in my opinion. Clerk Jim Clown. You guys, now it's a competition. Now it is a competition for the best handle. Clerk Jim Clown says hash values and metadata are banned from Auntie's court. Hello, Louise's Life, saying hello to everyone. Everyone say hi to Louise's Life. Oh, for the love of the traveling Mary. For the love of the traveling Mary. Yeah, Grace Base, you would think, right? It also seems like common forensic knowledge that you don't record steps from being in a car. Right, exactly. Because if you were on a road trip, it would say that you walked from Boston to DC. Like, yes, Emma, laughter has always been the best medicine. We need some today. It's been a heavy 2 days between Daniel Petty and Richard Allen. It's been a heavy 2 days. And this is just, is it crazy that I'm looking forward to seeing the fan tomorrow? I've missed the fan. I'm looking forward to being with you, all of us being together and watching the fan together, which reminds me, please hit the like button right now. You might have to close out the chat to do it. But there's, like 3,700 of you here, which is really great for a late night show because it's not late, but we miss our worldwide viewers because this is a worldwide story. And it's 8 p.m. here, which means it's 1 a.m. across the pond. It's tomorrow in Australia. So yeah, we're trying. Hit the like button because I've been getting shadow banned on Daniel Penny. Nobody wants to talk about it. Nobody wants me talking about it. And so I would appreciate it. Noni Lady, thank you so much. Wahoo! It's been a great year with you. Oh, 12 months. You're one of the originals. You are one of the first cupcakes, Noni Lady. I love you. Thank you so much. Emma, it's not a podcast. News Nation is a YouTube channel. It's also on your television. I have it on my television with Fios. So it is an actual channel on TV. So it is more like mainstream media. I don't think they broadcast live on their YouTube channel, but they may post it, like they may post this clip like tomorrow, the one that Mark's going to be on with Dan Abrams. But tonight, you may be able to go to newsnation.com and watch it. I'm not sure. I know you can go to courttv.com and watch like live Vinny when Vinny's on live. I mean, Rubber Duck Run Amok. There's another one. This is a stiff competition here, you guys, for best handle and best profile pic. Look at this. Look at Rubber Duck Run Amok. I'm a big fan of the fan. I love you guys so much. I just really do. Iceman says, Clerk Jim Clown, bro, you just literally brought tears to my eyes, and I'm loving all these handles. You guys. Aunt BB is also one of my original. Aunt BB was my first member ever. Love AJ and Yannetti, and if they haven't done this already, hire PI and prove Auntie Bev does interact with them, especially with the beach house accusations. That Venmo is making the rounds again. Julie Nagel to Ryan Nagel in the summer of 2022 for Frank and Beverly. It was brought up in the motion to recuse, and she said, oh, that's ridiculous. I've never rented out my beach house, and that's not how I spell Beverly. But her husband's name is Frank. Just coincidental? Suze is going to be at court at 10 a.m. tomorrow. I'll be there, as will Aiden. No fan. Large courtroom. Bad acoustics. Use your earbuds. Oh, okay, cool. Thank you. Thank you very much for that. Appreciate. Oh, Olivia's in the house. It's an all-star chat tonight. Somebody said, yes, Olivia, I agree. But now I got to go back and find Olivia's comment. Which I do not see easily. Hold on. I guess you didn't make the circle of trust. The circle of trust. This whole ducking case should be tossed into the frivolous lawsuit bucket. It's almost 2 a.m. in Germany, but you know what? Honey Bunny is here. Honey Bunny's here. She's with us. Chantal, one year of being a cupcake. Thank you, Chantal. Oh, thank you, Chantal. I love having you here. It's nearly been nearly 12 p.m. Oh, Cherie's down under. Cherie is down under, and it's nearly noon on Wednesday. It's already tomorrow. She's in the future. Cherie, what's going to happen in the future? Can you please tell us what's going to happen in the future? Thank you, Jane. Says I did great coverage on Penny. I'm going to continue to cover it because it needs to be talked about. It's a travesty that he's being prosecuted, in my opinion. He's a hero. Karen Reed's going to own Canton. All right, Olivia, I can't find it, but I'm sure whatever you said was highly intelligent because it always is. All right, moving on to the exhibits. Here's the application for the search warrant. And this, remember, originally this was in Stoughton District Court because it was a vehicular, what was it? A vehicular manslaughter case. It was not a murder case. So it was in Stoughton District Court, and this is hard to read. It's a little blurry, but I'm going to do my best. So this is Michael Procta, Trooper Procta's application for a search warrant. And here's what he wanted to seize: a cell phone, which was with this phone number that's redacted, Apple iPhone, a color rose gold with a crack on the back, dated 2/2/22. And here's what it is that they're looking for, that they want to seize. So here's what they're looking for. And here's so in your application for a search warrant, you have to give good reasons to the judge why they should allow you to go and take this thing that you want to take, or look through this thing that you already took, because he already took it. He already had it in his possession on January 29th. And in fact, I think he even asked Karen what the password was, so he knew how to open it. So did he not look at it until he actually was granted the search warrant? So that is curious to me. Yeah. Whoever was in charge of changing the printer toner must have quit that day. Yeah, at the Xerox machine. But in any event, here's what Proctor thinks he's going to find. Who's the judge that signed this, by the way? I can't read it. It's just a squiggly signature there. Addendum A. Data evidencing the identity of the persons owning or possessing the cell phone in the hours leading up to and during the manslaughter, negligent motor vehicle homicide, and leaving the scene of an accident resulting in the death of John O'Keefe on January 29th, 2022, in the area of 34 Fairview Drive. We all know it's Fairview. It's Fairview Road, isn't it? Because now I'm second guessing myself. I'm being gaslit once again. Being gaslit. Isn't it Fairview Road? Someone tell me that I'm right or wrong in the chat. Not that, Susan. Proctor's searching for the naked truth. Well, naked. It is Fairview Road, right? Yes, it's road. Thank you. Fairview Drive in the town of Canton, including any data evidencing movement. Data evidencing communications between, and so by February 2nd, I mean, this is when they're arraigning her, they're indicting her. You know, she's it's already a motor vehicle homicide, negligent, nonetheless, not intentional. Wouldn't become intentional until June, and that's when Karen Reed is brought into the station and says, "We're all in on the same joke, right?" Way before Aiden Carney ever started reporting on this case, almost a year before, by the way. And she says on body cam of Yuri, when they bring her into the station without calling Misty and Eddie, her attorney, that they know whom they know is her attorney, as a courtesy to say, "Hey, we're going to go pick up your client and upgrade the charges." No, they pull up and it's Proctor. He arrests her again and brings her down there. And she's talking to Yuri on the body cam. And I think we only heard the audio in court because they moved to keep the video out because they didn't want the jury to see that she was in custody. You couldn't really see her anyway because she was behind the computer screen. And she says, "Why am I here?" And he's like, "Oh, you don't have to talk to me. You're not your lawyer. You don't have to talk to me, but you can if you want." And she's like, "Well, why am I here?" He's like, "Well, now it's murder." And she's like, "We're all in on the same joke, right? My taillight was cracked and John was pulverized. He had the bejesus beat out of him or something. by Brian Albert and Colin Albert. Like, she says that, and it's recorded. And that was way before Aiden Carney ever started reporting on this case. This was in June of 2022. I saw some twidiots out there who happen to be like attorneys that are talking heads on certain channels, calling this a conspiracy theory dreamed up by a blogger. And no, it wasn't. It was that was the theory long before he ever started reporting on this case. So I think that particular YouTuber or talking head, or he did do an apology video saying that he was wrong, but data evidencing communications between John O'Keefe and the suspect, Karen Reed, including Catherine Camerano, Jennifer McCabe, and Kerry Roberts on January 28th, 2022 at 9:30 p.m. through January 29th, 2022 at approximately 5:30 p.m. Just remind me, is Catherine Camerano the wife of Michael Camerano? Olivia called him out. He called that attorney Rich out, and he admitted he was wrong. Woo-hoo. Yeah, he did like a whole apology video, but he's still digging in. He's on the JC side of things. By JC, I don't mean Jesus. I don't mean our Lord and Savior, Jesus Christ. I think Catherine Camerano, isn't she the nurse, right? She's the nurse. She worked in the hospital. And I think Karen did call her like the next day. Okay. And Mike Camerano is the one who drove John to CF McCarthy's, right? I believe, or they went together. Karen was speaking with Camerano that morning. That's right, because I remember she was so nice, that woman. She got up and she testified, and she was really broken up, and she talked about their conversation, and I think she was at work, and I think she was at the hospital. I think she's a nurse. And so that's what they're looking for. C, data evidencing communications in the evening hours of January 28th, 2022 at 9:30 p.m. through January 29th, 2022 at approximately 5:30 p.m. involving destroying and or concealment of evidence. Oh, well, this is really interesting because the 5:30 p.m. time is interesting. Okay. Because allegedly, this is another lie. This is another lie, right? In the search warrant. Olivia, have we ever seen these search warrants before? This goes directly to the lie of we seized her phone at 5:30 p.m. just like we seized her car at 5:30 p.m. And that was a lie, because when they got a hold of the Reed's Ring camera, it showed that the car was seized at what time? Something like 4:15 p.m. So he's doubling down now on the lie, and this is 4 days later. Olivia, has this been known before? Before the papers? Before the papers? He's lying again. Give me some Thompson twins in the chat, guys. Lies, 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 yeah. We're gonna get ya. They're gonna get ya. He lied in the search warrant to the judge to obtain the search warrant. He lied about the time. He puts approximately, but approximately 5:30 is not the same thing as 4:12. Thank you, Janine. Wow. Wow. More lies. More misstatements. 34 Fairview Drive. Data evidencing the location of the cell phone in the hours of January 28th, 2022 at 9:30 p.m. through January 29th at approximately 5:30 p.m. when her phone was seized. Oh, is it still daylight savings? Do we still not remember that you seized it before 4:12 when you got the car on the tow truck? This is big. This is huge. Olivia, what do you think about this? He was already setting the table with timelines from the start. Like, this is a material misrepresentation to a judge to obtain the search warrant to search the phone And he had to make it stick. He had to make it stick because they needed the taillight. It makes sense. Why would they lie? Why would he continue to lie about the time that he sees that phone? They still haven't seized him. They still haven't fired him. This is a cold read. I'm just reading this right now for the first time. So I'm just Scrivener's error. No, it's like, yeah, I mean, that's what they're going to say. Shock and horror. Yeah. But it's how many different times here so far? 1, 2, 3. And it's 4 days after the seizure. And he's got to stick to the timeline because they got to make it fit. Wow, they never thought this case was going anywhere. They never thought it would get to where it is today. Lying to a judge to get a search warrant is a really big deal. I don't know that there'll be any ramifications in, Norfolk County, but it's a problem. E, any installed computer application software, any related data files that will be necessary to detect and or access and read any of the computer files or applications described above. On a phone? Intentional errors and inverted videos. GP Dogs rule. It was just a typo. Amazing. 3 wrong characters in 2 separate places. Wow. 3 separate paragraphs. Chat's moving quickly, but I'm going to find it. Olivia, I think it shows Michael Proctor's consciousness of guilt and premeditation to destroy her taillight and plant it at the scene while making it seem impossible for him to do so time-wise. Yep. Because they already started finding some pieces in the evening hours in the dark. In the dark. After that vehicle was seized. And it was after, nobody really knows what time those first taillight pieces were found because, there's no evidence log. There's not even a log of who was on scene. Wow. You should be outraged. Hence the inverting of the Sally Port footage. True Crime with Eve. The pieces are starting to come together. Anybody out there from the Karen Reed is guilty hanger in Town Square that thinks that this is defensible, please, what is the excuse for this? What is the excuse? He just made a mistake. He just made a mistake when he wanted to get the judge to sign the warrant, hoping that maybe he would find some more stuff on that phone to incriminate her, but he didn't. Hoping against hope that he would find either something to incriminate her or at least some nudes. Because she was a whack job C word. With a leaky I'm not even going to repeat the disgusting things that came out of that man's text finger. And he wished that she would just kill herself. Because maybe that would have made his life a little bit easier. Because maybe at this point, he's in a little too deep. Wow, this is beyond. No wonder we never saw the search warrants, Olivia. And that was in Stoughton. That's how he got a judge to sign off on that. And again, the toner is out in the printer and nobody cares. Search warrant number 2. This is for, it looks like the same cell phone. It's an Apple iPhone with a rose gold with a crack on the back. Don't step on a crack or you'll break your mother's back. And this is signed by Daniel O'Malley. Wasn't he one of the judges that was copied on the private email of Michael Marcy when he wrote an email to the judge and others who did not grant, I can't even say the word grant, who did not, mind this only word appropriate here, who did not grant the restraining order that Chris Albert wanted against Aiden Carney. Daniel O'Malley was in that text chain. He was indeed. Oh, yes, he was. Oh, yes. Oh, yes. Oh, yes. Oh, yes, he was. Because he sits in Stoughton. Yeah. Mhm. He's one of them. Well, looks like he signed off on this search warrant February 2nd of 2022. He was the original judge on Karen's case. That's right. That's right. They did point that out. They pointed it out. Addendum A. Why is there a second search warrant for the same thing? Okay. Here's what they're looking for: data evidencing the identity of the persons owning or possessing the cell phone in the hours leading up to and during the manslaughter, negligent motor vehicle homicide, and leaving the scene of an accident resulting in the death of John O'Keefe on January 29th, 2022, in the area of, again, 34 Fairview Drive in the town of Canton, including any data evidencing movement. I mean, are we just going to call it 34? Is there a 34 Fairview Drive in Canton? Who can do a quick Google search? Because are they just trying to deflect from the fact that it's Boston police officer Brian Albert's house? I wonder if there is a Fairview Drive, because if there is a Fairview Drive, it's another material misrepresentation in the search warrant application. Hi, thanks, Cal. I mean, this is just riffing. I'm just improv. I'm just thinking of this stuff on the fly. Yes, with no motor vehicle accident report ever made, Wildman's mom. If they knew on February 2nd that this was a motor vehicle homicide, they are required under the law. They are required to do a police report for said motor vehicle accident. It involved a death, for Christ's sakes. It involved a death. And I saw somebody out there saying, oh, they didn't really need a police report because, he was dead. He wasn't going to go after her insurance or anything. Oh, really? Because that's exactly what his family is doing in civil court, honey. That's exactly what they're doing. That is exactly why you need a police accident report. Not to mention, it's not for just getting someone's insurance. It's the law. You are required to file a motor vehicle accident report under the laws of the state of Massachusetts. You can correct me if I'm wrong. Any motor vehicle accident involving personal injury or death or property damage over a certain amount, it is a requirement. It's not optional. You don't just say, oh, yeah, could you guys make a motor vehicle accident report so that we could, maybe sue later? No, it's the law. Name with the Grateful Dead references: Melanie Rippon, like Jerry in Seattle 95 on Scarlet Fire. You know it. My favorite years, I think, were like 89 to 91. Some really good shows in 89 to 91. But yeah, I'll allow it. No Fairview Drive in Canton. Wait, and somebody says, yes, there is a 34 Fairview Drive. Well, that's interesting. So I don't know. I have conflicting reports. And then no, there's not. But are we supposed to just know that? Is the judge supposed to Google the address to make sure it really exists? Huh. All right, moving on. Data evidence and communications between John O'Keefe and the suspect, Karen Reed, including Catherine Camerano, Jennifer McCabe, and Carrie Roberts on January 28th. Again, 9:30 to 5:30. Material misrepresentation number, I can't even count. Well, there were 4 in the first one, and this is number 56. Data evidence and communications in the evening hours of January 28th, 2022 at 9:30 p.m. through January 29th, 2022 at 5:30 p.m. Again. Somebody keep count. I'm losing track. Involving destroying and or concealment of evidence. Well, you didn't find that. But I mean, can we really trust anything that Trooperino, Nicholas Garino, does anyway? Data evidencing the location of the cell phone in the evening hours of January 28th, 2022 at 9:30 p.m. through January 29th, 2022 at approximately 5:30 p.m. when Karen Reed's cell phone was seized. Okay, so if you got her location data, you knew that she was back at One Meadows by the time she connected to the Wi-Fi there at 5:36. Why in the name of the traveling Mary, Lally, would you open in your opening say the evidence will show that Karen Reed backed up into John O'Keefe at 12:45 a.m.? You had the location data. Any installed computer application software, any related data files that will be necessary to detect and or access and read any of the computer files or applications described above. Exhibit 2. Well, that just may have been a copy of the front. Maybe they put it in there twice by accident. All right, so here's another search warrant. And this is to Verizon. Now, this has something to do with the car, right? Because it's got a VIN number on it. And an ICCID number and an IMEI number. So, and Verizon number assigned to IMEI. Why would it have a VIN number unless it didn't? It must have something to do with the car, like the telematics stuff. So this was not, they didn't request this one until December 7th of 2022. And this is signed by Douglas, tell me chatters, Wilkins? Looks like Wilkins. Judge Douglas Wilkins. It's a Superior Court judge now because this was when it was already transferred to Superior Court. Yeah, this is Norfolk County. Law doesn't apply here. Yes. Oh, yes, Scott, my amazing moderator. 25 years on the job, NYPD. Don't forget, they initially went with a domestic assault and still didn't do what they were supposed to do, right? Would have been arrest her at the scene. Because Yuri testified, he called the medical examiner's office and said, we're treating this as a domestic. They thought she hit him with the glass and they didn't arrest her, and they're supposed to, right? Any injury involving a motor vehicle accident requires a police report. Thank you, Lois Lane. I know that I have some bodily injury claims adjusters in the chat. Some of you worked for State Farm, Allstate, Liberty Mutual. Would you ever pay on this claim without a motor vehicle accident report and without any injuries that you would typically see in a pedestrian knockdown case? And you don't have to take it from me, having 30 years experience as, a civil litigator handling hundreds, if not thousands of car accident cases, including pedestrian cases and dog bite cases. Take it from the bodily injury adjusters in the chat who will tell you it's impossible to not have injuries below the neck if a pedestrian is struck by a car. Kristen said, I looked up Fairview Drive and it showed Fairview Road. There you go. Callie Lily says, Callie Lily, insurance and state requires a motor vehicle accident report. Yep. Olivia, the law in Norfolk County? What's that? Sherry said, I went out of my mind when she said that. And the thing about only for insurance purposes. Yeah. Kimmy, oh, what a tangled web they weave when first they practice to deceive. I mean, it makes sense why he would wish that she would just kill herself, because that would make his life a lot easier, wouldn't it? Chupa Procta, right? This is all intentional. Nothing ever happens to these people. Nothing yet. Nothing yet. Thank you, Lindsay, for backing me up. Yes, must be reported to the RMV. We call it the DMV here, but I guess you guys call it the Registry of Motor Vehicles, and the police by way of an accident report. They didn't do it. They just didn't. And you got to ask yourself why. If you're going to make this, if you want this to be a motor vehicle accident report, wouldn't that be the first thing that you would do? Wouldn't that be the first thing? Wouldn't that be the first piece of evidence that you would worry about? Because even without taillight pieces, if you have a RMV report that says it was a car accident, it's evidence that you thought it was a car accident, not just your self-serving statements in an affidavit 4 days later where you lie about the time that the phone was seized. Debbie, were they sloppy because they thought Karen was going to plead guilty, or were they sloppy because they're completely stupid and thought they would get away with it? I mean, pick one, flip a coin. I think they thought she would plead. And when she didn't, because she's a tough chick, they decided to upgrade those charges to murder. Put the heat on, pin it on the girl. There's some people out there that are afraid. They're very afraid. And you know how I know that they're very afraid? Because they're coming for me. They're coming for me. Search my name on Twitter. You'll find it all. You'll find all the horrible things they say about me. You'll find all the clips that they clip of my shows trying to say that I'm saying something that I'm not. When I said the other day that it was delicious and delightful, they're trying to say that I'm saying that against the O'Keefe family, that I'm saying that I'm saying it's delicious and delightful that they lost their son. Are you kidding me? It's delicious and delightful that Marcy is going to be exposed and all his personal emails are going to be exposed. And all of you people and your self-proclaimed best friends are scared. And you're scared of me because I make a hell of a lot of sense. So you can try and discredit me, say I'm not a criminal lawyer and I have no idea what I'm talking about. But when you protect your tweets and the only people that can respond to you are the 5 other people that follow you, give me a break. Bring it. I'm sorry that I'm making such a difference in your lives that you feel the need to, that I live rent-free in your head on a daily basis. It's sad that you have 16,000 tweets all about the Karen Reed case. Really? Do you really have nothing else to do? I mean, hi, Goodmans. The Goodmans are here. Everyone say hi to the Goodmans. We love the Goodmans. Thanks. Thanks for the vibe. It has been a great year, Noni. It has been such a great year. And Chantal, also for a year. And let's see, we discussed this. Suze. Misty, I don't know if we did this. Will the defense be able to bring in all butt dials missing, deleted texts, and all the coincidences from the first trial? Yeah. I mean, everything that they had for the first trial, they can use in the second trial. I don't remember if the judge allowed it in, but they can certainly make their arguments again. I mean, they were questioned about the butt dials, and that was pretty awkward. The day that Brian Albert testified that he sleeps with his phone in between him and Nicole every night on the regular, and that, he butt dialed Higgy, and then Higgy butt dialed back, and nobody ever picked up the phone, and they were getting intimate that night, he said. And that's how it happened. Yuri's math teacher gifted 5 memberships. Thank you so very much. And if you were gifted by Yuri's math teacher, please thank Yuri's math teacher, who is so kind and generous always to the channel. Thank you so much. Turd Ferguson, who wrote my amazing, amazing theme song. I love my theme song. It gets stuck in my head. Thank you, Turd, for being here for 10 months, for hanging in. Baby Fish Mouth is sweeping the nation. Love you, Mel. Love you too. Love you too, girl. Jerry Gray, thanks for tuning in from Canada. Did Karen Reed's phone have a crack on the back, or was half of it missing? Interesting. Like the video. All of the missing videos. And look at Stephanie gifting 5 memberships. Thanks, Stephanie, if you were gifted by Stephanie also. Thank you, Stephanie. Love you. And she also became a member, or re-upped, because I know she's been here for a long time. And RL South also became a member. Welcome to you. Look the other way. We will not, says True Crime with Eve. We are outraged, Eve. We are outraged. Misty, will they even get reprimanded for any of this? I don't know. I wonder if the internal affairs investigation is even has this information, if they're looking into that as well. These lies to the judge to get the search warrant. I mean, if you lie to get a search warrant, Doesn't that become like a fruit of the poisonous tree thing? But they didn't find anything in her phone anyway. Well, they did, kind of. Except everything that was in her phone with regard to John was also in John's phone, so they found it there too. Will they ever get reprimanded? I mean, it's a Proctor issue, and I think he's already under investigation, so probably. Hi, Liz Reed. Dad embodies faith, love, and strength that have always led our family to peace. Thank you. Liz Reed is also the daughter of Bill and Janet Reed. Thank you, Liz Reed, for being here. We send prayers up to your family. And your father is an amazing man. I had the pleasure of meeting him when I was in court in June. And really so kind, so generous, so genuine. I hope they call him as a witness. I really do. There could never be a better advocate for Karen than Bill Reed. So please bring it. Thank you, Lise, for becoming a member. Tracy says they wanted to see if she had access to the Ring program. Maybe, but we do know that Michael Proctor had access to it when he got a hold of John O'Keefe's phone. Thanks, Tracy. Chantal, wouldn't the lack of a police report cause problems for the O'Keefes in the civil case? Oh yeah, I've been screaming about that for a long time. But a lot of people out there don't think I know what I'm talking about. Actually, one person said, Melanie's an idiot. She doesn't know anything about the law. Is she really even a lawyer? There's no way that the McCabe's or the Alberts would ever have to pay money in any civil case because they could never be found guilty in any civil case. First of all, honey, nobody's found guilty in a civil case. It's called libel or negligent. And second of all, perhaps you should look up and research third-party pleadings in the state of Massachusetts and then get back to me and then revise your tweet because some of your followers corrected you. I know you're Jen McCabe's best friend, but really you just sound kind of stupid because anyone else that Karen Reed's defense team thinks could be responsible for the death of John O'Keefe will be third-partied into this case. You can bet on it. So there's that. It's just the stupidity out there it's free. Stupidity is free. And then protect your tweets so nobody can respond to you who has any common sense or knowledge other than someone who actually did tell you that you were wrong. Lisa Gonder, thank you for your super sticker from Canada. For 2 super stickers from Canada. Kimmy, they lied about 32 Fairview, stating the Albert's address, misspelled trooper names on the reports. Yeah. They just did. Thanks, Kimmy. Jerry Gray, my favorite part of sending a super chat is the message my phone gives after a purchase. You're all set. If you know, you know. Yep. You're all set. Ding, ding, ding. You are all set, Jerry. You're all set. Amy in Boston is a new member, but has always been a member, so maybe just re-upped. Thank you, Amy, and welcome. Barbara. Hello, Barbara. Thanks for the 20. Hi, Melanie. This is definitely a fishing expedition or trip. Nope. Not going to catch any fish. No, they're out there. They're out there. If you live here near me, you know about the canyons. If you fish for tuna and marlin, they're out in the canyons. They're looking for marlin and tuna. That's how deep sea fishing this is. Who, if anyone, became a member, welcome. Mama She, hello, sweetheart. How are you? Thanks for the 5. We are shocked, in horror, and outraged. And PU. Thanks for the 5. Says, Melanie, you're the sunshine in our cloudy days. Oh, thank you. That means a lot to me. It really does. I appreciate each and every one of you. I love you with all of my heart. If I don't see you soon, I'm gonna die. Name that movie. Michael, tell the pretty girl you love her. I love you with all of my heart. If I don't see you soon, I'm gonna die. All right, moving on to Addendum A. This is to Verizon, this search warrant. Melanie, the mofos don't know you. I'm seeing if anybody gets the movie. Godfather, James Lynch, first in. That is the Godfather. Michael, tell the pretty girl you love her. So many movie quotes, so little time. Just like Petty Paralegal says, so many errors, so little time. So here's the Verizon search warrant application, actually, for a VIN number, I guess, for Karen's car. with the circuit card identification number, the international mobile equipment, the Verizon phone number associated with it. For the time period of January 29th, 2022 at 12 a.m. through January 29th, 2022 at 7 a.m. And he even put in what time that would be in UTC. Wow. Did he write this one? Did Proctor write this one as well? Hold on. Well, we can't really read it because it's very faint. So they're looking for subscriber records. All information for the account associated to the above referenced IMEI VIN number, including all subscriber information to include the name, tax ID number, physical address, mailing address, residential address, email address, any other information, credit information obtained or used by the company to grant its account status. Is this for like the Wi-Fi in her car? Olivia? Did you fax this from 6 other fax machines? Wow. I don't know if there were any deletions on Karen's phone after it was seized, Ken. That's a great question. It's George's Bank off Massachusetts for deep sea fishing. I guess if you know, you know. Yeah, they're just keeping her Lexus, Bob Weir. Bob Weir's in the chat. Bob Weir's here. Weir everywhere. Yep. You're just, keeps getting stranger and stranger. What time is court tomorrow? 10 a.m. Godfather. Reed is coming to them. All right, so they're looking for all of this stuff having to do with the car. The specialized location records. All call, voice, text. So this is, they got all this stuff already. Olivia, I'm gonna assume that I'm gonna assume that you have this, but if you don't, let me know. So let's get on with the show. That's right, Sua Sponte. Let's go. Feel like a stranger. Gonna be a long, long, crazy, crazy night. Why would they keep her car? It's evidence. It's evidence. Remember, they let the jury look at it the first time. They've got her car. She's still making payments on it. I'm sure she never wants it back after this anyway. I mean, I don't know. This looks like somebody a little more talented than Proctor, who asked for all of these things and stuff. They wanted all of this time on tower and/or sector, electronically stored records. I mean, this looks like a form that they use for every car. They just scratch and sniff the VIN number. Carrier key related to call detail. But I thought this was related to her cell phone. Why is there a VIN number associated with it? I'm just confused. Here's the application for the search warrant. It was Proctor. A 15-page affidavit. Denme says it's intended for use or has been used in the means of committing a crime, has been concealed to prevent a crime from being discovered, as evidence of a crime or as evidence of criminal activity. And this was for Verizon. Okay, thank you, Olivia. These are related to the data stored within the car's infotainment system, which connects cell phones and thus has overlapping data. So they should have had all of this information as early as December of 2022. Why did they have to? I mean, I guess there's more information in the chip off procedure, but okay. Then they should have definitely been able to know her location because they would have like the GPS of the car in there. So Proctor didn't even bother to ask for this until December 7th of 2022. And again, it looks like Judge Douglas Wilkins signed off on this. And here's Exhibit 3. And here's the extraction report from Karen's phone. You'll see, it's hard to see. Let me move myself out of the way. But if you look here, this is the Celebrite extraction. The Apple iOS full file system done by Trooperino. These are the calls between Karen and her dad. So the first call prior to January 29th, 2022 at 6:30 a.m. was on, I can't read this, January 16th of 2022. It's hard to tell. It could be 16 or 18. At 4:47 p.m., she made a call to her dad at 3:17 a.m. The next phone call to her from this phone was not until January 29th, 2022. It says, to dad, outgoing, January 29th, 2022 at 6:30 and 48 seconds. That was a 1-second phone call. The next one, 6:32 and 15 seconds, was a 3-minute and 51-second phone call to dad, outgoing. To dad, outgoing, 6:40. That one was 0 minutes and seconds. To dad, January 29th, 2022, 6:44, 17 a.m., 11 seconds. To dad on January 29th, 6:44, 55. It was 4 minutes and 5 seconds. To dad, outgoing, 1:29:22, 6:49:22, a minute and 35 seconds. And is there anything unusual about this at all? She just found her boyfriend dead on the lawn of Brian Albert. People who have close relationships with their parents would obviously be calling their parents. I don't know why people think it's so unusual that she would be calling her father. January 29th, 2022 at 7:11 a.m., outgoing call. 7:11:36 for a minute and 26 seconds. So those are all the calls between the 28th and the 29th. And the last call before the 29th, there was nothing on the 28th. The last call before that was at least this was the 16th. It looks like the 16th or the 18th. I can't really read it. It's right there. They've got it from Karen's phone. They don't need it from Bill Reed's phone. Because, you know, they took her phone at 5:30. Wink, wink, nod, nod, say no more. And here are the text messages from Karen to dad. From dad to Karen. It says, I'm up, just heard the phone. This must have been the call that he missed. Looks like, I mean, I can't read it. It's really hard to read, but it looks like it's around 6 something a.m. Really bad copy here. Next message from Karen to dad, John is dead. And then they had their phone calls, I guess, after that, because he probably called her right away once he got that message. That's chilling. Thanks, Angela, for becoming a member. Karen Randall says, thanks for making duck our new adverse word. It's perfect. It's perfect. It's ducking everything. It's ducking crazy. It's what the duck. It's who the duck was in charge of writing that search warrant application. Why the duck didn't they find what they needed? Why the duck did they wait so long to request geofence data? And then why did they only request it of Android phones and not iPhones when everyone in the house had an iPhone? I have so many questions still. Blondie time, thanks for the 10. YouTube socials et al. Include a toxic sewer full of dwellers with nothing better to do than harass others. Please get a German Shepherd for protection stat. Joking aside, be safe. Actually, I have Chloe. Chloe was rehomed to me. I went to Vermont, met the woman halfway. I've got her here just in case she's ever needed for anything. Kimmy says Jen deleted her daughter's text. Why can't Mr. read? I don't think he did delete anything, but I think that you're right. When Jen willingly handed over her phone, she said, well, they said I could delete all my messages with my kids, so that's what I did. Turns out that some of those messages were pretty important. Some of those messages between Jen McCabe and her daughter may have been very important about what happened the night of the 28th leading into the 29th. And she was permitted to delete them all. Sure, go ahead. Delete whatever you want. Lindsay, thanks for the 5. Yes, there were deletions from Karen Reed's phone in April of 2022. While in police custody, came out of trial through the defense's expert witness. Oh, that's interesting. I don't remember that. I honestly don't remember that. Thanks, Lindsay. Jackie, thanks for being here for 4 months, and it's 1:36 a.m. in the UK, and Jackie's still here with us with a very cute puppy in the profile pics. Thanks you, Jackie Young. Garina says, Lissa says, Garino testified that Karen Reed called her dad at like 1 a.m. that night, so Garino just straight up lied? I think she called her mom. I think that's what it said in the papers, but did Garino say that she called her dad? So yeah, then he did straight up lie. He did. We'd have to go back and watch his testimony again. I'm sure that some of you will. But yeah, she called her mom, not her dad. I mean, what the duck, Alyssa? What the duck? I mean, as if that's not enough for us to do tonight, we still have to look at the Bederow letter. You wanna flip over to Aiden Carney? I also have something very interesting too. Just kill me, Garino. Yep. Just kill me. Colin was never in the house when John was there. I feel really bad for the children that were dragged into this. I really do. I really do. I think it's horrible if they were harassed or, horrible things were done. I think it's terrible. I think parents should not drag their children into such things as like this, if it can at all be avoided. And that goes for, the O'Keefe children as well. The niece and nephew being dragged into that civil case. I don't think that's a good idea. I feel like, shouldn't we protect the children? The fact that John's niece is now a plaintiff in that civil suit claiming emotional damages means that her entire medical history is going to become discoverable. Any emotional history she has for any therapists, counselors that she saw as a result of her mom's death, or her dad's death, or John's death, all of it. It's all coming in. It's all discoverable. It's an emotional damages case. Oh, you guys saying that Turtle Boy's not going live tonight? Oh, okay. So I can keep going? I mean, I forgot that he usually goes on at 9 anyway. All right. That's cool. We'll keep going. And so I think that, just leave the kids alone. But, it doesn't mean I'm going after the family. I have a great sympathy for the family, enormous sympathy for the family. I can't imagine what it would be like to lose your daughter and your son-in-law and then lose your son. That's unfathomable. Absolutely unfathomable. And despite what Jennifer Coffendoffer would like you to think, I have never, ever said a mean word about the O'Keefes, ever. I have great sympathy for them. Despite the way she tried to conflate Nancy Grace's tweet about YouTubers attacking, you know, Abby and Libby's families with me and some other YouTubers attacking the O'Keefe family, Coffindoffer in her tweets. It's absolutely untrue. But, only like maybe 74,000 people saw it. Could be on its face defamatory. We'll see. Not like I don't have an entire team. People are really stupid on the internet. I don't know why they're so stupid on the internet. You're going to see how stupid people are on the internet, and it's just causing them more trouble. It's like, do you think if you don't if you keep spouting nonsense on the internet, there's never going to be any ramifications for your behavior? Because Mark Bederow is here to tell you that there are going to be some ramifications for your behavior, and let's read about it. In the latest letter from our friend Bederow to Robert Cosgrove, the 17th or 400th special district attorney in the county of Norfolk, because it's like the county where everyone is conflicted because, they have to keep hiring outside. They got to go out of pocket from their own district attorney's office because nobody wants to retry Karen Reed in that office. So they had to hire the hired gun, Hank Brennan, $250 an hour for a cap of $75K. They're also paying Robert Cosgrove, and they're also paying Mello Yellow, who I don't know. Does anybody have proof of life on Ken Mello? Does anybody know if he's among the living? Because he's just disappeared. He just disappeared. Nobody knows where he is. I don't know if anybody's seen him. Does anybody have proof? Did you ask for proof of life? Thank you, Decline. I love you too. Thank you so much for thinking I'm the best. I appreciate you because a lot of people hate me. So for each person that loves me, for each 100 that loves me, there's like one who hates me, and they have 10 sock puppet accounts. So Lindsay says, yes, Green testified during Cross. The only deletions on Karen's phone was from April 22nd. And of course, Lally brushed over it real quick and on to the next. Ooh, I guess I just did not pick up on that. And I was here with you for every single day, except for the one day that I was in court. And the one day that I was in court was the day that Jessica Hyde testified, and it was the beginning of Trooper Paul. It was the direct examination of Trooper Paul, and Mama She says, yes, please protect the kids 100%. Yeah. Thanks, Mama She. We try. All right. Bederow dropped a bomb yesterday, another bomb, potential bomb for people trying to flex again on YouTube. This was on YouTube, actually, in the chat on YouTube, on the Mafia Masshole live stream that happened the other day. I don't even know which one it was because I don't watch it, but what's up with the dude who sits in the dark? Does anybody know? Like, I did tune into Glare for a little bit, and he was like restreaming it, and there was a dude on her show who like sits in the dark and has ski goggles on, it looks like, and I don't know who it is. Who is this person? They call him Boomer. Oh, there's Mike Crawford. He's like, I'm tuning in. It's time for I'm ready for my close-up. He's like, I'm ready for my close-up. Hi, Mike. Olivia says, Green testified the GPS location data was deleted from Karen's phone while in police custody in the spring of 2026. Oh, so no wonder. So no wonder Lally's timeline was all screwed up. Wow. I think we need to point that out a little bit better next time, because if I missed it, I know that you don't miss a thing. I don't remember them closing on it. 1 hour for closings was nowhere near enough time in this case. I am going to petition right now, 2.5 hours per side, and they will use every minute of it. They got 2.5 hours in Delphi. They didn't even use it. And that was a way shorter trial. Sarah Boone's stylist has a picture of what I think is Ken Mello as a profile picture with a CPAP machine. Maybe not a CPAP machine. This is terrible. And I don't know if this is fake or real. So if it's fake, I'm going to say great job on CapCut or whatever editing program you use. And if it's real, I'm really sorry about his health. But Sarah Boone Stylist says we probably won't know about Mello until January. I'm I would never laugh at someone's illness, but if you did doctor that up, it's amusing. So if he's sick, then I hope that he gets better real soon. Okay, here we go. November 11th, 2024, via email to Robert Cosgrove, the Special Assistant District Attorney of Norfolk County District Attorney's Office. He is the prosecutor who is now prosecuting or persecuting Aiden Carney in one of the many cases that Aiden Carney has against him, or all of them, maybe all of them. I'm not even sure. This is, I think this docket number is for the wiretapping case. So there's a wiretapping case. There's some witness intimidation cases. There's all kinds of cases against Aiden Carney, basically because they wanted to shut him up. And then what they did was, what had happened was, then perhaps the confidential, not so confidential informant, Kate Peter, who has a nickname that I don't like, so I don't use it, who had Tully and Mello on speed dial, was texting their personal cell phone numbers while Aiden Carney was at Lindsay's house, and Lindsay was in the bathroom, and they were trying to set up some fake witness intimidation charges for which Lindsay was not even a witness to anything, although they did serve her with a grand jury subpoena for a grand jury that had already concluded, and a fake grand jury that the crime hadn't even been committed yet for. So in order to charge him with witness intimidation of Lindsay Gattani, who was his girlfriend at the time or ex-girlfriend at the time or booty call or whatever she was, in order to make her a witness for purposes of that witness intimidation statute that we talk about a lot, they had to serve her with a grand jury subpoena because then she was a witness. But see, the thing was, there was no grand jury. See how twisted this is? So twisted. Dear Mr. Cosgrove, Aiden Carney stands accused of illegally wiretapping Lindsay Gattani on December 23rd of 2023. In essence, Mr. Carney is accused of briefly recording Ms. Gattani without her knowledge during an hours-long encounter between them. And that's when it was. It was the day before Christmas Eve. And that's when perhaps Kate Peter, Lindsay, Tully, and Mello conspired to get Aiden Carney over to Lindsay Gattani's house because now she's a witness. They had a plan, and it's all there. They've got all the text messages. I know I do. I really do want to laugh. I do. I want to laugh so badly. And so Aiden, maybe he doesn't have the greatest taste in women, except for now. It seems that his girlfriend Meredith is very, very nice now. But, there's been a couple crazies in the backstory. A couple crazies are in the backstory. Several of them were perhaps conspiring with Lindsay and KP, including that Leah person, Jen Duso. Not even, maybe the crazy comes out of the box a little too late for Aiden. But in any event, Aiden recorded her because he had a feeling, I think he had an inkling that perhaps maybe his intuition is good. Like, I think she's going to try and set me up. And he recorded her. And so this is for the wiretapping charge, which is different from the alleged assault charge, which was dismissed when they said that he pushed her down on the couch. I think that one went away, right? The evidence that resulted in Mr. Carney's wiretapping indictment consisted of testimony from Massachusetts State Police Lieutenant John Fanning and Ms. Gattani, and two separate clips of Mr. Carney allegedly recording Ms. Gattani. Okay, so at the grand jury, Fanning testified, Lindsay Gattani testified, and then they had two separate clips that were played for the grand jury, audio clips. One was approximately 15 minutes. One approximately 15-minute clip was posted on Mr. Carney's YouTube show in December of 2023. I have heard parts of that. You cannot unhear it. It is very, very uncomfortable to listen to. It is a woman becoming unhinged, talking about a pregnancy that turned out apparently maybe to have been not real pregnancy, and threatening to, or says that she did actually take abortion pills and that she was going to drive to his driveway if he left and have the this event that the pills would cause in his driveway, and was waking up. She's in the process of waking up her 4 children to bring them with her. It is horrific. I couldn't even listen to the whole thing. I tried and I couldn't unhear it. It is so hard to listen to. So I suggest that you don't, unless you want to, in which case you can go over to Turtle Boy's channel or his webpage, and you can listen to it there. But it's very disturbing, and not on his part. It is disturbing for the things that she says in there. And he's trying to like say, I have to leave, and she's begging him to stay, and it's really, really disturbing. And I don't think she's faking it. Like I don't think she's faking the emotion and faking the hysteria and the hurt that she's feeling, or whatever it is. It's really, really, really horrible. The begging for him to stay, and the threats that she's making about if he doesn't stay, this is what she's going to do, and the the waking up of the children. And yeah, he was very calm. He tried calming the kids down, and Kelly, I'm with you. I have mad respect for Aiden's ex-wife. She's pure class. Yeah, I mean, I I don't know anything about her, but I think she's staying out of this. Rightly so, and God bless her and the children, all the children. Very Amber Heard. I mean, it's unhinged. It is really disturbing. And so he records it for 15 minutes, and it says here that he posted it on his YouTube show in December of 2023. And remember, this is what led to his arrest and his incarceration. So it was because of this event that they set up that he was already had charges pending for alleged witness intimidation against Jennifer McCabe, Brian Albert, Colin Albert, Michael Proctor, Yuri Buchanek, Chris Albert, all of these people. And he's out on bail. And this was the violation of the bail conditions that led to him going to jail for 60 days. So she sounded jilted. Yeah, it was so disturbing. And then, like, it turns out, apparently, maybe, and I don't know, the pregnancy wasn't real. The sonogram picture had some metadata on it that may have been from a long time ago, years before this. So, and apparently there may be some other witnesses who are going to say this is not the first time that she has, maybe said this to another boyfriend. And it's really disturbing. Anyway, moving on. So he posted this on his show in December 2023. Lieutenant Fanning testified in the grand jury that someone captured another approximately 30-second clip after it was posted online. See the February 22nd, 2024 transcript. So that was the grand jury used to indict him after this. That wasn't the grand jury where they tried to indict Karen and Aiden for conspiracy. It must have been for this. Okay. Oh, come on. I like a continuous scroll. According to Lieutenant Fanning, the clip retrieved from Mr. Carney's YouTube show includes Mr. Carney stating that he was recording the conversation between himself and Ms. Gattani. The 30-second clip does not contain that statement. Right. So in Turtle Boy's version of it, which is 15 minutes long, he says to her, I'm recording this. I'm recording this. After being questioned by a grand juror, Lieutenant Fanning admitted that the someone who provided the 30-second clip to the MSP was, in fact, Catherine Peter, a.k.a. Masshole Mafia, a.k.a. Kate Peter. Hi, I'm sure you're watching. Hey, what's up, girl? Who sent the clip to Detective Lieutenant Brian Tully, the former supervisor of the MSP Norfolk County Homicide Unit. Footnote 1. On October 18th of 2024, Tully, who remains the subject of an MSP internal affairs investigation, was removed from his position for the best interest of the MSP's public safety mission. Notably, DL Tully was removed without a replacement, such that this important position remains vacant. To the extent that DL Tully's removal from the Norfolk DA's office was a demotion or otherwise related to his misconduct, demand is made, pursuant to Giglio versus the United States and Graham. Beverly Cannoni loves to cite Graham also. For any and all such evidence in your possession, custody, or control. Citing a Boston 25 News article. They want everything on Tully. And it wasn't until a grand juror asked the question, who gave it to you? Who gave it to you, Fanning? How did you get it? He just said someone on direct examination. And one of the grand jurors was smart enough to say, who gave it to you? And then he had to admit that it was Kate Peter, KP, Mafia Masshole, Masshole Mafia, whatever it is. The queen of the massholes, as you're going to find out she's called, who sent the clip to Tully. Because she had a cell phone number. They were texting a lot. And that's also in the transcript of 2/22/24. Lieutenant Fanning was unable to explain whether the 30-second clip Miss Peter provided to DL Tully was the entire clip that had been posted and then removed from the internet. Ms. Gattani testified that she listened to both recordings and did not consent to being recorded. She later speculated that it was her belief, this is her testimony in front of the grand jury, that Mr. Carney edited the original recording by adding language of him informing her that he was recording her. And that's also in the transcript. On November 10th of 2024, just 2 days ago, Sunday night, today's Tuesday. Sunday night, Ms. Peter hosted a YouTube show in which she criticized Michael Crawford, the host of the YouTube show Young Jerks, who is in the chat. Hello, Mike. Which regularly broadcasts about the Karen Read case. Ms. Gattani watched Ms. Peters' show. Shortly before the show started, Ms. Gattani wrote in Ms. Peters' live chat, Mike Crawford is the one who edited/manipulated the wiretapped audio/video of me for Aiden Carney. Oops, did I say that out loud? Followed by 3 question marks. When asked by another individual in Ms. Peters' chat whether Mr. Crawford really did that, Ms. Gattani doubled down on her, quote, factual claims, stating, he most certainly did, and our queen shall be bringing the proof tonight, I believe. Happy face, footnote 2. Our queen. The queen of the masshole mafia. Footnote 2. Ms. Peter did not allege on her show that Mr. Crawford edited or manipulated the audio or video at the behest of Mr. Carney or anyone else. Okay. Props to Kate Peter for not being stupid enough to fall for it. Maybe she was going to, until Lindsay started going off in the chat with her weird flex. I don't know. Bederow goes on to say, Ms. Gattani is the prosecution's central witness to the wiretapping indictment against Mr. Carney. As detailed above, she has publicly and unequivocally asserted as fact that Mr. Crawford and Mr. Carney conspired to alter a recording to make it appear that she consented to a recording. Considering Ms. Gattani's public claims, we expect that she has made similar claims to the MSP and or yourself, and that in doing so, she provided the proof, in quotes, against Mr. Crawford and Mr. Carney. Accordingly, pursuant to Giglio versus the United States and Rule 14 of the MRCP, we demand immediate production of any evidence or statements, whether documented or oral, he said oral, in your possession, custody, or control provided to you by Ms. Gattani, Ms. Peter, or any other source which tends to prove that Mr. Crawford, quote, edited or manipulated video to help Mr. Carney, or alternatively, that any of them falsely claimed the same. Footnote 3. Mike has made the record. Legitness. I'm sure he doesn't want to, but I'm sure you can read between the lines here that neither Bederow nor Aiden is accusing Mike of doing anything. Footnote 3. Mr. Crawford has emphatically denied, quote, editing or manipulating any video. Ms. Gattani's unequivocal public assertions accusing Mr. Crawford of committing a serious crime, which could subject her to a libel claim, likely will severely impair her credibility at trial. I mean, that's being nice, Mark. Mark has such a nice way with words. He really softens the blow. To the extent you're aware that she's made similar statements which are false, the defense is entitled to this evidence as impeachment material. Yeah. Whether she lied or she thought she was telling the truth, either way, we're entitled to it. Because here she is on YouTube, weirdly flexing in the mafia masshole chat. I mean, people just don't know. I mean, this is really the masshole mafia because the mafia knows better. The mafia really knows better. First of all, there's no mafia. There's no such thing as the mafia, but the mafia knows better. You don't talk on the phone. You don't go in people's chats and spew nonsense like this. You just don't. But maybe it's I guess it's a parody. I guess the name is just a parody. Okay. Okay, that was footnote 3. We appreciate the courtesy of your prompt disclosure of the requested information. If none of the requested information is in your possession, custody, or control, please notify us of this fact as soon as possible. XOXO, respectfully, our friend, Mark Bederow. Chef's kiss. Chef's kiss. And you know what? He wouldn't have had to write this letter if these people were not spewing nonsense in the chat of a live stream. You're making your own bed, girls. You're making your own proverbial bed, and you just keep digging it further and further and further. Crazy Mel, thanks for the 10. Can you take action against Coffin Doofus for her slander? It's actually libel because it's written. So the way I remember that, the way that, law school, there was slander is spoken, SS. Libel is written. Could be defamatory. Some of the things she said about me could be defamatory. She says that I should have my license taken away, things like that. I'm not really interested in, getting into it with her, but who knows, she keeps it up. I mean, it's just, I don't have patience I don't have time for the drama. Like, I wouldn't even want to spend the physical or emotional energy in even pursuing it. It's just like STFU. How about that? Just STFU. Somebody needs to tell her what the law is. Somebody really does need to tell her because apparently she doesn't know. I mean, obviously she's not a lawyer. I don't even really know if she was some sort of an FBI agent. I think she did firearms training or taught people how to shoot for the FBI. I don't know. But she needs to take a step back and reel it in a little bit. Take a step back and another step back and another step back because the people in the front row are getting all bug-eyed. Anybody know what that's from? I know there's some people in the chat who know. My deadheads in the chat will know what that's from. Bill, thank you for your super chat. Really appreciate you. Nicholas Lee, thanks, says thank you for being you. Love your commitment to the cases you cover. You are my go-to. Thank you. And it's funny because that's Nicole. I'm sorry, not Nicholas. Nicole Lee. I only pick cases to cover that I feel really passionately about one way or another because otherwise it would just be boring coverage that everyone else is doing. And I need to have I need to feel something. Thank you, Rosalie, for becoming a new member. The Traveler says, so now they can hire a special prosecutor, but can't pay to get air conditioning for the courtroom. Love your show. Thank you. Yeah, they just got Wi-Fi in there 2 weeks before the counter trial started. That's true. I swear, pinky promise on that. That's really true. Latina, is the CW going to be okay if Mr. Reed upgrades his phone? How about if he deletes his calls? How about Mr. Reed screenshots what he wants to show? Mr. Reed cuts up his SIM card, changes his number. Oh, Latina, you're on it. Fire girl, you're fire. Thank you for the 10. Can Mr. Reed say 115 was a butt dial? It's not in the call log though. It wasn't. He didn't. She called her mom and she didn't answer. So, the whole thing is just gonna get stranger. Ms. Holmes 66, thank you for the 10. Melanie, you the woman. The recording was gut-wrenching to listen to. Yes, LG needs serious help. I don't know what her issues are, but I don't think she was acting in that call. Let's just put it that way. It was genuine emotion. It was genuine horror, and it's horrible to listen to. And I don't know if she's listening, but like, just take care of yourself. Just take care of yourself. Stop. Try and get out of all this drama, and just take care of yourself and your kids, and you'll be okay. It's just, it's horrible. What's this whole thing is just so gross. All of it. Just like, you don't need this in your life. LG needs to, she and KP are the devil incarnate. Lucky for the CW. I mean, like, anybody, why do you invite this vitriol and this hatred and this negativity? Why do you let people live rent free in your heads? Why do you make it your life's mission to try and destroy Aiden Carney? Like, why? Hell hath no fury, I guess. I don't know. Some guy with cancer. Again, thank you for the 2. And as always, I'm really sorry about your cancer. And I hope you're doing all right. The rule is always in cash, never in writing. Yeah, the mafia. If the mafia existed, which, it doesn't. Thank you for becoming a new member. I mean, it's like, what the duck, you guys, because you can't make this up. Oh, Yannetti and Jackson, Corruption Crushers. I did a Grateful Dead's Touch of Grey Goodbye tribute to my favorite therapist of all time. 15 years in a group home. Ages 13 to 15 with her. She bawled. Oh my, I'm going to cry. 40 years later, our bond remained strong from California to Maryland. That's amazing. I love that. I love that. I love all my deadheads in the chat. I think in song lyrics, there's a deadhead poster behind me. I may move it over there so it gets better plug. I went to the Sphere. If you follow me on Instagram, you might have seen my video from the Sphere, and that was an amazing experience. And listen, the Grateful Dead for me growing up, because I've been on the bus for a long time, since I was like 13, and the Grateful Dead was like something to look forward to. They always came twice a year, fall tour, spring tour, and it was like, all right, like whatever you were going through at the time, whatever, adolescence, growing up, college, grades, stress, boyfriends, breaking up, divorce, marriage, babies, all the stuff. It was always like, all right, going to the shows, every spring tour and fall tour was like setting the reset button of life. And it's like a place where there's no other place like that I've ever found. No other community where there's, 50,000, if it was a stadium show, 50,000 people all smiling at the same time for 6 hours straight. And it was always something to look forward to. Like, all right, well, fall tour's coming up, spring tour's coming up. And I remember going to some shows at Foxborough back in the day. I want to say it was summer of 90, 91. It was wicked hot. And they were hosing the crowd down. And those are some really, really good times. I saw so much of the country from following the Grateful Dead around. And, my parents were music lovers too. Not that they were into the Grateful Dead, but Neil Diamond, and my mother slept out. She loved Perry Como and the Kingston Trio. And like, they would go see Sting and Cher, and Neil Diamond was her big thing and still is, but he's not really touring anymore. And so they got it, but they were like, why do you have to go to 8 shows in a row? I remember Jerry was on Broadway, did that Broadway run. Like, why do you have to like go to because it's different every night. Why do you go to the Jets game every weekend? It's different every time, right? It's different every time. Crazy. Foxborough was summer of 89, was it? Probably it was also 90, 91 too, right, Jason? Kimmy, Touch of Grey and Wish You Were Here, Pink Floyd. I followed Fleetwood Mac and Stevie Ray Vaughan. I would love to go see Stevie Nicks. I would love to. I would love to. All right, what else do you guys want to talk about? Oh, do you guys want to see the piece that that David Yannetti wrote for Boston College Magazine? I mean, for BC Law. Yeah, I think we should see it. David Yannetti, class of 89. Have you guys seen that? Am I going to lay some more knowledge on you? I thought it was 91 too. I thought it was 91, Foxborough. It may have been 89 as well, but I think the show that I'm thinking of was the 91 show. And I think it was like, not maybe 4th of July weekend, but I want to say, because I remember going to Oxford Plains 4th of July weekend. That was summer of 88. And it was so hot. They were hosing down the crowd. Kingston Trio is still around. Oh no, wait. I saw them in Eisenhower Park for free. One of the guys popped a guitar string and he just kept playing and singing while changing the string. Yeah. Crazy, right? Such good times on tour. Such good times. You saw Bob Dylan 50 times, Marisma? Even went to his hometown years ago. One time, I don't know how long ago it was. It was a while ago. I want to say could have been like 15 years ago. I saw Bob Dylan. I don't remember if it was the Coliseum, Madison Coliseum, or if it was the Madison Square Garden. I was close to the front row. And I took my camera out and I took a picture and I nearly got tackled by a security guard who was like, Mr. Dylan does not want anybody taking his picture. And I was like, he should be happy that somebody wants to take his picture. Like, what? Like, Bob Dylan should be happy. He is one of the greatest poets of our time. I will say that. I think he is the most covered artist and songwriter. And the Grateful Dead played a lot of Dylan. Remember that whole Dylan and the Dead tour? They did a whole tour together. It was Dylan and the Dead. And so those shows were good. I can't remember what year that was because, the older I get, the more time flies and I have zero idea. You're kidding. Your name comes from a Bob Dylan song, Karina. Bob Weir also has a song. Karina. Is that it? Is that a Bob Dylan cover? Because Bob Weir sang that with Rat Dog, with his band Rat Dog. Karina. So I wonder if it is the Bob Dylan song because, as such, we said the Grateful Dead played a lot of Dylan songs, and that may be the Karina. When I see your name, that's what I think of. I think of the Bob Weir version, the Rat Dog version. I miss Rat Dog. I saw the Grateful Dead with Jerry something like, I never counted, but it was like between close to 200 times with Jerry. Because, you would go to like however many shows a year, just add it up. I'm old. You had a dog named the Mighty Quinn. That's a great song too. Yeah, amazing. Bob Dylan and Van Morrison in 2000. I saw Van Morrison once at Forest Hills at the tennis stadium, the old tennis stadium. I forget what it was. It was like the Guinness Flawed. Remember that Guinness Flawed or some sort of like festival? He came out. He started singing one song. He didn't like the way the sound sounded, and he stormed off stage and never came back. Van the Man. What? Have I ever played an instrument? No. I played a little piano when I was a kid. I still know how to play Stairway to Heaven. And if you go into Guitar Center, there's a big sign like, if you play Stairway to Heaven, you're going to get kicked out. Like, but it's the only song I know. I had a boat named Sugaree once. That was interesting. Okay, here we go. Defending Karen Reed. This is BC law. David Yannetti, class of 1989, provides a look at his role in one of the highest profile Massachusetts murder cases in years. Oh, there he is. Our man. I know that his mom is a big fan of the show. So Mrs. Yannetti, if you are watching, and Queen Tanis, if you are watching, David Yannetti's sister, I love you both with all of my heart. And you raised a great man. Look at him. Look at him out there fighting for truth and justice. And you can tell that he really believes in his client's innocence. Oh, thank you, Anne, for your Venmo, who says, great show. And Dennis, thank you, who says, you're so well-spoken. Thank you very much. I feel like I have no voice. And Denise says, I'm so happy I found you. Keep being amazing. Thank you guys for your Venmo. I appreciate you guys so much. If you want to ever remain anonymous, just say anon, please, as your first comment. Just like Dumois. Does anybody know about Dumois? Dumois is like a gossip site on Instagram. And people put in tips of where celebrities are, and they say, anon, please. And they have merch that says, anon, please. And I love it. I love that picture. And while I put some chapstick on, because it was wicked windy today. When Mark Bederow and I were walking from the courthouse to Little Italy for lunch, it was like the wind was whipping. I knew it was going to be windy, so I had a coat and a scarf. Mark was freezing. I have a coat. I'm like, Mark, where's your coat? What's wrong with you? Don't you know we're like in the tunnels of wind? Yes, we're going to go. We've been talking about it. Andrea and I have been talking about our shared love of the Grateful Dead. I did not know that she was a deadhead until one of you guys pointed it out to me. So when I reached out to her during Delphi, I'm like, is it true that you're a deadhead? And she lives near the Gorge. So that is cool because that's a bucket list venue for me. I've never been to the Gorge. I hear it's amazing. But that's like the full-on commitment to go to the Gorge. Like you need to stay in a place there. You need to camp. I don't really like camping. I'm not a camper. So I would love to go see either Dave Matthews or, I don't think the Dead's coming back. But if they do, I would love to go to the Gorge. And I would love to go with Andrea. And you know what I'm going to try and get her to do? I'm going to try and get her to go to the Sphere with me when Dead and Company comes back to the Sphere. Because I just heard they're coming back in like May of 2025. So I love my destination concerts, as you know. All right, here it is. David Giannetti, 1989, is a defense attorney in the Karen Read case. Oh, this is small font. I'm going to have to turn the chat. I can't see the chat right now, so here we go. It's not often that defense attorneys are met with autograph requests, flashing cameras, and media frenzy when entering a courthouse. For David Giannetti, class of 89, however, this became his reality during the trial process of Karen Read, his client, whose case took Massachusetts by storm last summer. Again, this is in the Boston BC Law, Boston College Law magazine. At a BC Law event sponsored by the Criminal Law Society on October 28th, Giannetti spoke on his legal background, his journey from prosecutor to defense attorney, and the process of becoming one of three counsels for Karen Read, who was charged with second-degree murder, motor vehicle manslaughter while driving under the influence, and leaving the scene of a collision causing death. When it came time to return a verdict, however, the jury was in a deadlock, resulting in a mistrial on July 1st of 2024. So he just spoke to the law school recently, last month. I mean, it's only November 12th. This was like recent. Oh, I wish I knew I would have went. He didn't tell me. He didn't tell me his touring schedule. Although I probably couldn't get in. I'm not a student. Giannetti began his legal career as a prosecutor, working for the Middlesex DA's office for 10 years. I was very associated with law enforcement and Massachusetts police, he said, citing an example. You get called out at 3 a.m. on a cold winter's night to see a body in the subway station, and you can't help but bond with your colleagues. He saw state police as terrific investigators and terrific people. So I'm going to say he worked with the MSP as a prosecutor. If he graduated in 89, let's say he got admitted in 90, let's say from 1990 to 2000, or 89 to 99. That kinship didn't always sit well with new colleagues when he transitioned into criminal defense. I'm not the profile of a defense attorney who ordinarily would be taking shots at the state police, he explained. Still, he believes his perspective of the prosecutorial side has served him well in defending Read. In January 2022, during a Massachusetts blizzard, Giannetti received what he thought was just an ordinary client phone call. A woman was on the line sounding confused. She told Giannetti she thought she was being investigated for hitting her boyfriend with her car. Giannetti accepted her as his client and began his usual procedure. He sent a letter to the state police and DA's office informing them that he would be representing Karen Read and that there was no need to arrest her because he would surrender her. And then this header, or quote, with more than 3 decades of trial experience to draw upon, Giannetti said he's eager to go the distance in the Read case. Things didn't go as Giannetti planned. 9 out of 10 times, because of my history as a former prosecutor, I have some credibility, or used to, he said. This was the first sign that I got that this case was going to be a little different. They ignored my promises of cooperation and arrested her 2 days later at her house. I mean, I've said this before, that I was shocked that this happened because she was represented and they knew. And Mark Bederow will tell you, and any other criminal defense attorney will tell you that if they know that your client is going to be arrested and they know that you're representing the client, especially if you used to work for the DA's office, that's the courtesy. Can you bring her in? Can you surrender her? And they arrested her 2 days later at her house, didn't even give him a heads up. The next turning point for Giannetti was a phone call from an anonymous source who first claimed to be Mike Lynch, a popular sportscaster. He told Giannetti that Read was innocent and that he should look at the homeowner of the property where the death occurred and his nephew. They beat the victim up and left him outside, the caller claimed. It was then that Yannetti started to get the sense that there was more to the case than met the eye. He found himself fighting to keep bail charges at a reasonable amount and for discovery evidence to be turned over. We were being stymied in our ability to get people to talk to us, he said. We knew people out there knew more than they were revealing. We believe that there were a lot of untapped sources. Reed's trial was not immediately publicized, but that all changed when a blogger named Turtle Boy picked up the story. In his talk at BC Law, Yannetti was quick to say that he had concerns about Turtle Boy. He described him as someone who had bashed the hell out of one of my clients 6 or 7 years ago. He was somebody you want to keep at arm's length. The tactics he uses are not the tactics of a refined defense attorney. They don't put the date in here, but Aiden Carney did not start reporting on the Karen Reed case until something like April of 2023. Still, the blogger's attention to the case jump-started the media swarm and, as Yannetti put it, the tremendous Free Karen Reed movement. Reed has also become active in the case. Yannetti said her participation has been both unusual and impressive. Karen Reed is a sophisticated, smart professional. There are currently 3 lawyers working full-time, but she's really the 4th lawyer on the case. She's gotten a better education on what it's like to be a lawyer than if she went to 3 years of the finest law school in the country, he said, with an amused nod to his alma mater, which I think I'm standing in right now. Yannetti's own law education was instrumental in discovering his passion for trial work, in part through BC Law's moot court and mock trial programs. It was an unbelievable experience. I never pictured myself as someone that would be able to speak in public, let alone be an actual trial lawyer. Now, with more than 3 decades of trial experience to draw upon, Yannetti said he's eager to go the distance in the Reed case. We didn't get the result we wanted. I think it's clear there'll be an alteration of the approach. Now we have transcripts, videos, tapes of testimonies, and we will be using all of that to help us decide how to approach the retrial, he said. All right, you heard it. You heard it straight from Misty Yannetti's mouth. There's going to be an alteration of the approach on the defense. The process will not be easy, but according to Yannetti, it's worth fighting for. As many friends that I have in law enforcement, there's a segment of law enforcement that can't stand me. If those are my enemies, then I'm probably doing something right. It's a nice little article in the BC Law magazine. Right? All right. Thank you, Justin Green, for the Cash App. I appreciate you always so much. And thank you to Jennifer Aniston, who's asking me to join her broadcast channel for animal rescue and adoption. Thank you, Jennifer Aniston. I appreciate you too. You can't make this stuff up, you guys. You just can't. Mel, you should play David Yannetti's reenactment of his closing in the Jeff Curley case. So good. I don't know where can I find that, Stephanie? I don't even know where that is. I love Mr. Yannetti. Look at Misty and Eddie. Love it. I love it when you guys change your name. That's amazing. Yeah, and explain why Proctor hates that. Right. Proctor hates that man. That was in his text messages too. He sent a picture or something of Yannetti and he said, I hate that man. Yeah, love Jennifer Aniston too. Me too. I love the morning show. A lot of people didn't like the morning show, but I really love the morning show. Risa says, Karen is smart enough on her own to be a lawyer, but learning from a Yannetti and Jackson. Yeah, what a dream team can come true right there. Maybe she'll go to law school. There's a way that you can take the bar exam in certain states without going to law school if you work for a law firm for a while, and she really could qualify, but she still has to study for the bar. There is a way to get in. I know in New York there is. I don't know about Massachusetts. Right. He hated him already on 12922. I wonder why. I wonder if he was involved in another case that Proctor was involved in. Kat Randall, thanks for the 5. Is it possible that a change of administration that governs the DOJ may take a new look? One can hope. I think somebody started a petition to ask the new president to please keep Josh Levy on. I don't know. I don't know if that's going to work. Usually they do like to change administrations in the U.S. Attorney's Office, but it'll be interesting to see. I mean, I think, I don't know. What do you guys think Josh Levy's doing a good job? Yeah, it is really good. You're on season 3. Love the morning show. Maybe the Walsh case, but I don't think that Yannetti is involved in the Walsh case. Right? Yeah, that's it. That's it. Little Cupcake always coming in with the real story, the real details. Because he dared go with a third-party culprit defense and begin with Karen Reed was framed. Proctor hated that. Yeah, and we are outraged. Right? Right? Oh, Stephanie sent it to me. Stephanie sent it to me. Is it? It looks like an interview. Does he do? Hold on. Oh, they're doing his closing. Okay, so hold on. I got it. This is like 3. Okay, so he's reenacting his closing, and this is from a prior case. I'm just going to fast forward it a little bit. Stephanie, you guys want to watch this? I think we should watch it. I think we should watch it. This is awesome. Right? Yeah, in Virginia, you can do that too. Thank you, Stephanie, for sending this to me. I've never seen this before, so I would like for you guys to see it. Let's watch it together. Let's share it together. We're only 2.5 hours into this. Come on, we're this is like nothing for us. We go for 6 to 8 hours at a time. This is we're in amateur land right now. This is the Jeffrey Curley murder case. David Yannetti is going to reenact. Apparently, he's going to reenact his closing. Thank you to Stephanie for sharing this. I haven't seen it. Have you guys seen this? I haven't seen this. This is from 3 years ago, April 7th, 2021. I think we're in for a treat. Thanks, Steph. You guys are so collaborative here. I love that. Just one of the many things that I love about you. Poor Jeff Curley. I don't even know about this case. I don't even know about this case. Can somebody give me a quick synopsis about the Jeffrey Curley case? Was horrific, and Yannetti was fabulous. And here he's going to come up and he's going to do. He's going to reenact his closing. Some people haven't seen this. All right, I think we're ready. Ready for Yannetti. I mean, who's not ready for Yannetti, right? Here's Mist T and Eddie. That's Nicole. But there's like 5 versions of Misty and Eddie. But she's Miss T and Eddie. You're not missing any tea tonight, girl. You're getting all the tea. You're getting all the tea. Trigger warning? Oh, okay. Okay. Thank you, Michelle. It's sad. Okay. All right, you guys, ready? He's reenacting his closing statement, his closing argument from the Jeffrey Curley case. Oh, Rassler's mom. I always put the link to join in. Look in the show notes or in the video description. I think that works for iPhone too. But maybe the mods have an iPhone link for you. Thank you for wanting to join. It's I don't know. YouTube keeps changing their whole format and stuff, and it's like hard to find stuff now. And you have to close out the chat to hit the like button, which I suggest that you do right now before we oh, I love you. I love you too. I love you too, Nicole. I had lunch with your friend today in Little Italy. We met in the courthouse in Manhattan. We had lunch in Little Italy together. It was like a 3-hour lunch. We had a lot to catch up on. Somebody said here that it was a 12-year-old who was killed by a child victim of SA and murder. Oh no. All right. It's very sad and powerful. This case put David on the map here in Boston. All right, buckle up, buttercups. Here we go. Do we need tissues? I got my tissue right here. Don't worry. Thank you, Scott. All right, here we go.
We'll now hear David Yannetti's closing. Counselor, your closing argument, please.
Thank you, Your Honor. May it please the court. Ladies and gentlemen, over the course of the last 2 weeks, you've heard from 60 witnesses, over 200 exhibits, You've listened to a lot of testimony, much of it technical, all of it important. But I suggest to you, despite the length of this trial and the number of witnesses and the number of exhibits, this is a very simple case. When you boil it down, this case comes down to the fact that 10-year-old Jeffrey Curley left Cambridge one afternoon and he never came home. He never came home because two men killed him, and they killed him because he would not do what they wanted him to do.
Okay, he was the prosecutor in this case. I just want to clarify. He was the prosecutor in this case, and apparently this little boy was 10 years old.
Jeffrey Curley said no. Jeffrey Curley resisted. Jeffrey Curley fought. And for that, he had to die. That's why we're here today. That's what this case is about. Now, there are a couple of ways to look at this case, really. 12 of you will do that when you retire to that jury room and you evaluate the evidence and you come to a true and just verdict in this case. But I suggest to you, there are really two ways to look at this case. You can either believe the words of Salvatore Siccari in his final version of a statement that he gave to the police after 18 hours of lies. You can either believe his statement or you could disbelieve the words of Salvatore Siccari. But I suggest to you, whether you believe his final version of a statement to the police or whether you disbelieve it, he is guilty of murder in the first degree. Let's look at his statement. Let's take his words at face value and let's assume that he's telling us the truth. If that's true, then Salvatore Siccari is guilty of murder in the first degree as a joint venturer. Now, Justice Cowan will instruct you on the law of joint venture, and I suggest to you all three elements are present in this case. The first element, being present at the scene of a crime, that's a no-brainer. Salvatore Siccari tells the police, trying to shift blame away from himself and onto his friend, Charles James, he still tells the police he was present for this murder. The second element, sharing the intent for the crime. Well, he doesn't use those words. He doesn't say, I shared the intent for the crime. But he tells you what he did that day, and that tells you that he indeed did share the intent for the crime. Do you recall his words? He told the police that when he showed up in the neighborhood in Charles James' car, as they had been doing for months, as they were spending time with this boy and befriending him and seducing him, taking him to restaurants and buying him toys and promising him a bike and so forth and so on. This day, however, when they showed up in that neighborhood and they see Jeffrey Curley leaving his grandmother's house, running to their car to be with his two pals, Salvatore Siccari tells the police that he ducked down in the car. He ducked down. He didn't want anybody to see him. Now, if this were an innocent excursion, like all the others, if he had no idea what was to happen later that day, why is he ducking down? For what reason? It's obvious, isn't it? He's telling the police, he's telling you, he knew exactly what was going to happen that day. This was the big day where the seduction was going to pay off. And he wasn't going to let anybody see him in that car. He knew what was going to happen. He shared the intent for that crime, and that second element of joint venture is satisfied. And the third element of joint venture, again, if you believe his words, participation in the crime, well, do you recall what Salvatore Siccari told the police? Again, in this final version, where he's putting himself in the best light possible. He said that when Charles James was dragging this poor boy into the back seat of that car, what did he do? Did he call the police? Oh my God, there's this 300-pound monster dragging a boy in the backseat of the car. No. Did he yell for help? Please, anyone, stop this man. No. Did he go up to Charlie, his pal, and say, hey, what are you doing? This isn't what we talked about. Get off him? No. Did he grab him and throw him off him and say, stop? No. Did he do nothing? As his attorney argues today, was he merely present while the murder was taking place? No. He told the police that he quickly ran around the car and closed all the car doors and then got in the driver's seat and took off so that Charlie wouldn't get caught. And then as they're driving along the road, he looks in his rearview mirror and he thinks he sees the boy's arm go up in a struggle, and he thinks he sees a cruiser behind him. He punches the gas to get out of there so that Charlie could finish the job. If you believe Salvatore Saccari's own words, he is guilty of murder in the first degree by joint venture. But folks, you are not required to believe his words. You are entitled to reject those words, and you are entitled to look at the evidence in this case for the answers that you will need. The evidence in this case tells you something quite different, does it not? It took Salvatore Saccari 18 hours to come up with this final version of events, putting himself in the best light possible, shifting blame to the 300-pound monster, according to his attorney. He didn't call him that day. That day he called him friend. But it didn't take Salvatore Saccari 18 hours to tell his girlfriend what had happened. He and James went to that Home Depot and they bought the concrete and the lime and the Rubbermaid container, everything they would need to dispose of this poor 10-year-old boy's body. And after they put Jeffrey's lifeless body into that container and filled it with concrete and took it to the Great Works River and pushed it over the bridge, and it splashed in the river, and Jeffrey Curley's body sank to the bottom of that river. Saccari's on the phone to his girlfriend. He doesn't tell her everything, but he tells her all you need to know. I just hurt somebody really bad. I just hurt somebody really bad. What else do you need to know? The evidence in this case tells you what Salvatore Saccari did. I suggest to you on October 1st of 1997, this was indeed a big day for Salvatore Saccari and Charles James. This was the day when the seduction was going to pay off. All of the dinners and the toys, we're going to buy him a bike today. And then we're going to have our way with him. But something went wrong. Something they didn't count on. This 10-year-old boy said no. He refused. He fought with every ounce of energy that his 10-year-old body could muster. He fought them, and for that, he had to die. They decided to kill him. They decided it. And then they acted upon that decision by forcing him to inhale gasoline vapors from a gasoline-soaked rag. That, ladies and gentlemen, is premeditation, making the decision and acting upon the decision. And that's what Salvatore Saccari did. That is what those two men did. That is one theory of first-degree murder, and it is present in this case. But it is not the only one. Judge Cowan will instruct you that there is another theory called extreme atrocity or extreme cruelty. You will make this decision. When you do, realize that you are the conscience of this community. You decide whether their behavior was extremely atrocious or extremely cruel. And to do this, ladies and gentlemen, I'm sorry. It is uncomfortable. Nobody wants to think about this, but you must. You must think about the way that Jeffrey Curley died. This was a big day for Jeffrey Curley as well. Imagine his horror when his friend Charlie and Sal are pulling him into the back seat of that vehicle. It is uncomfortable, but you must look at those autopsy photos. And again, I apologize for introducing those. Nobody should have to look at those photos. It is unnatural, but you must, because that is your job. You saw in those autopsy photos that Jeffrey Curley had red burn marks on his forehead, his eye, his cheek, his chin, his neck. What does that tell you? That tells you exactly what Jeffrey Curley did. And it tells you the fight that this 10-year-old boy put up against these two men. They tried to smother him with that gasoline-soaked rag, and Jeffrey Curley fought, and they couldn't get it on his nose and his mouth. And he was going on his eye and his forehead and his chin and his cheek and his neck. Imagine the horror that he's feeling, the betrayal, the pain, the burns. But the worst was yet to come, because it was inevitable that they would overpower him, and overpower him they did. They got that rag over his nose and his mouth. And you heard the testimony of the medical examiner. That would have immediately caused him problems in breathing. And Jeffrey Curley would have panicked. Panicked. Why are Charlie and Sal doing this to me? My God, it hurts. And then the gas would have been transported to his heart. And it would have caused an irregular beating in his heart. And he would have known it, and he would have felt it. And he would have panicked even more. Ultimately, the arrhythmia in his heart, according to the medical examiner, would have worsened the fluid in his lungs, and it would have felt to Jeffrey Curley as if he were drowning. He did all he could, but it was inevitable, and Jeffrey Curley died. That was the manner in which he died. And when you consider whether he died in an extremely atrocious or extremely cruel manner, you may consider Salvatore Siccari and Charles Jane's indifference to his suffering. You saw them on that Home Depot video. They may as well have been at Stop and Shop, buying a Rubbermaid container with concrete and lime. And you know something else, because the receipt was found by the police in the excellent investigation they did of this case. That receipt told you everything you needed to know about Salvatore Siccari's feelings toward this 10-year-old boy as he lay in the trunk of their vehicle. That receipt reflected that they stopped at that Oscar drug and they purchased 2 cigars for the ride to Jane's apartment to smoke along the way while the lifeless body of Jeffrey Curley lies in their trunk. Ladies and gentlemen, both theories of first-degree murder are present in this case. The evidence screams extreme atrocity or extreme cruelty at you. I ask you to find Mr. Siccari guilty of murder in the first degree and nothing less.
Mic drop. Mic drop. Anyone? I'm going to imagine he got the conviction. I didn't know anything about this case. Thank you, Stephanie, for sending this to me so that we could watch this together in the comfort of each other, because I'm now going to fall into this rabbit hole of the Jeffrey Curley case. He was 10 years old when he was murdered in 1997. I don't know when the trial was. Was it shortly after 97, or did it take a long time to find them? That was the closing. That was the closing. Right? I mean, that is like masterclass in trial lawyering and masterclass in closing arguments. That is the difference between a prosecutor who believes in his case and a prosecutor like Lally, who was phoning it in till the very last word. Thank you, Stephanie. That was horrific, but thank you for that. I need to go back and watch it. I don't know when that was, but it was chilling. They were arrested right away. So it was 1998. They were both convicted. Thank you, Mary. And for all of you who are deeply affected by the Jeffrey Curley murder case, I'm sorry. And David Unetti was the prosecutor in that case, and he was reenacting the closing. Maybe there's a foundation or something for Jeffrey Curley, and maybe that's where he did it. I don't know what that was about, but yeah, mic drop. Yeah, absolutely. Hi, Andrea Clark. Well, thank you for that, Stephanie. That's exactly what we just did. Thank you. Dewey, favorite David Unetti moment when the reporter asked, will Lucky still testify? Yes, he will. Wry smile, and God bless him. There are a lot of them. Wrestler's Mom, you found the link. Thanks for becoming a member or renewing. Dawn is behind, I believe, but is saying, why are they only asking for the hours of 5 a.m. to noon on the 29th? Actually, they're asking for midnight on the 29th to 5:30 p.m. on the 29th when they seized her phone, but it really wasn't 5:30 when they seized her phone. It was really like 4:12. The glare is my boyfriend. YouTube member. All right. Does he know that? That's awesome. The did a good job on the washer case. Says the glare is my boyfriend. Might be some typos in there, but thanks for the deuce. And I'm so happy for you and Glare. I hope you guys are gonna. Is it official? Is it like Facebook official and YouTube official? I'm shooketh from that. I'm gonna fall into a deep rabbit hole tonight on this case. Thank you, Anne, very much for your Venmo, and to all of you for being here with me tonight. I am going to see you again tomorrow morning at 9:30. We're going to start early. The hearing is at 10, the motions hearing on Karen Reed. We're going to come back. We're going to do it all again tomorrow. Because, if I don't see you soon, I'm going to die. As soon as I end the stream, it's going to teleport you over to tomorrow's stream. We do need a good laugh after that. Can somebody say something funny? Can somebody say something funny in the chat, please? I'll wait. I'll wait for it. And in the meantime, if anybody has access to docket number or document number 415 in the Karen Reed case, it's not out yet. I can't get it, but it's been filed. It's another discovery dump document. It's a Commonwealth notice of discovery. We must be up to like 48 or 49 by now. If anybody has that at any point before tomorrow, if they would like to email to me, as always, I am so gracious to all of you who are so collaborative. Let me just see if there's anything else. I'm waiting for a response to the Boston 25 stuff, but they may not even be opposing it. I'm thinking they didn't oppose the stuff on Gretchen Voss from the last pretrial that we did. So the defense may not be opposing it. Yeah, it's Commonwealth's notice of discovery XLIX, which I think is 49. And that is document number 415, which I can't seem to get a hold of. So if anybody, Glare says it is nice. It's nice to meet your girlfriend. Is he here? Your girlfriend came in and she gave me $2, and her super chat was a little I don't know. It was a little, I couldn't understand it. I'm not going to read that out loud, but it's very funny. Corn Pope. Oh, Unetti won an award, and that reenactment was at the ceremony. Well, he deserves every award for that. And he has it memorized. It's ingrained in his brain. And this is from 1998. I don't know when that ceremony was. It says 3 years ago, but it may have been older than that. Maybe it was just posted 3 years ago. Maybe. Who's got the funny thing? Who's got the funny thing? Oh, yeah. Apparently, Mark posted a picture of us on Twitter today. I had to give him permission. I'll show it to you guys if for those of you who haven't seen it. Because he sent it to me. So hang on a second. Oh, I can't wait to read how many nasty comments are underneath it. But, I mean, them's the breaks, I guess, when you're like YouTube famous. I guess, if you're a public figure, people can just, be as mean to you as they want. It's like acceptable, apparently, in some circles. I don't know. That's what they say. So, well, it's a little bit of a close up. He says, I ran into somebody I know today at Manhattan Supreme Court. The lighting was so horrible in that hallway. And there we are. Let's see how many nasty comments there are about us. But, go for the comments. But wait, I thought Melanie Little was on vacation with Alan Jackson in Cancun. All right, you win. Judy Moody wins the day. Judy Moody wins the day. Bederow Little 2028. That's hilarious. The two best in the business, Melanie breaking out the Burberry. All right, well, all right. So far, not so horrible. Not so horrible. Young Jerks put a cupcake in there. That's nice. All right, I'm sure that all the nastiness will be out there soon. Somebody said I look younger. I look younger in that picture. All right, whatever. Very cute. Very cute. Thank you. Thank you. Thank you. So that's cool that he won an award, and that's it. I will tell the Glare that I talked to his girlfriend next time I talk to him. Nobody has anything funny to say, so I think we're gonna wrap. And we're going to see each other at 9:30 tomorrow morning, bright and early. Oops. Kate Sharp is Clubber's girlfriend. And Cheryl's RV Travato Travels became a new member. So welcome. Welcome. We're very happy to have you. I don't know what's going on here. What's going on here? And Kat Randall coming in and gifting 5 memberships at the end of the night. Cheryl, it says you joined twice. I don't know how that's possible, but like it comes up once. Thank you, Kat Randall. And thank you. Welcome to the 5 new members who were gifted so very kindly by one of our very favorites, Kat Randall. All right, you guys, we'll see you bright and early tomorrow, 9:30, in case we get any new docs that we got. And Cat Artist coming in with this last minute 5 for the super sticker. I love you guys. You guys are awesome. Again, as always, thank you to the moderators who make this an amazing, fun, and kind place to be, hopefully. Hopefully it wasn't too rough in there in the chat today. That case must have shook you, Nettie. Totally. Yeah. Totally. I know. I do turn it off, but sometimes I have to just, laugh about it, because I don't also think that people should not just be able to get away with saying whatever they want to say about people. Like I think they need to sometimes be called out about it. You know what I mean? Like, I'm old enough. I'm like so old that I don't care. Like, it doesn't bother me. But what really upsets me is that, like, our young people, like our kids, are growing up being totally like bullied on the internet by people who can hide behind fake names, and like there's never any ramifications, and that's not okay. Some of us can handle it, and it's just not okay. And it's all women out there doing it too, which is so disgusting. It's really, really, really gross. Oh, you saw me at the Sphere? Why didn't you come over? That's so crazy. You were on the floor too? I was on the floor. Why didn't you come over? You should have totally come over. I would have loved it. I was wondering if I was going to see anyone I knew. I did see I went with a bunch of people that I knew, and a bunch of people that I know were there. But yeah, it was a great time. You should have totally come. If anybody ever sees me anywhere, do not ever be shy. Come over. Come on over. I love to meet you. I love to talk to you. I love to take pictures with you. I loved it when I was outside of the courthouse that day that I came to court. It was heartwarming. It was lovely. It was wonderful. I would never, ever be rude. And I would absolutely, Sunny Job, next time, come over. Come on. Oh, please show it again. Oh, Jane. Oh, is that the Jane? No, that's Jane. Is that the fake Lindsay Jane? No, you'll have to rewind, Jane. Jane's here, everyone. Jane's here. No, they do. Oh, there's a lot of them. There's a lot of them. There's a really mean one today about Ali Mata and I was like, really? I don't. I'm off Twitter, Karina. They drove me off of Twitter because I just decided I didn't have any. When I started covering Karen Reed, they're trolling me hard. So I do not do Twitter. I was never active on it anyway. I was just like, you know what? I don't have the patience in my life for all of this hatred. And then people become consumed with it, and they do nothing all day except look at it. And it's a very there's no added value to having that in my life. I just don't need it. I don't need the drama. I don't need the hatred and the vitriol. So it's just one less time waster for me, and I don't do it. I refuse to play in that cesspool. It's insane. Good night, everyone. Stay safe. All right, you guys, be cool, be kind, be classy. Stay that way. I know you are. I love you. All right, I'm gonna teleport you over to the morning stream so that you can hit the bell and come back tomorrow. Smash the like button on your way out. Smash the like button on the way in. Thank you so much for talking. What if they want to sell you 10 acres of land? Yeah, don't try and sell me 10 acres of land. But if you want to come over and say hi, yeah, I have in my opening, Janine, in my opening video, there's a selfie that Dave Matthews took of me and everyone in the crowd. And I'm like right there in the third row. So that is my favorite venue as well. I may see you there. Check it out. It's in the opening. I want to get to 100,000 this year, guys. I want to get to 100,000 subscribers. I think we can do it. I don't know. We're already in November, but we're up to like almost 72,000. So we just have to keep on getting it up there. I want that plaque. I really want that plaque. All right. I know it's silly and it's like, materialistic, but I really want that 100,000 plaque. So let's do it. Let's do it. All right. Love you guys. Let's see you in the morning. Smash the like button on the way out. Smash the like button on your way in. You know the drill. All the YouTube-ish courtesy type things that YouTube likes. See you tomorrow. Peace.